May I please your office?
Yes.
My lord, I beg to mention item number 30, my lord. My lord, orders matter. My lord, earlier order, my lord, it would be, my lord, Borpeta instead of Bozal. Only a correction of a word, my. So, my lord, taken up it at 2, 30.
Just wait. We'll after the mentioners, we'll take it up serially. Those IAs. Just wait for some time.
Hold on.
Apply.
May I
Yes.
please, Your Lordship? My lord, I have prayer in item number 4 and 11, my lord. In item number 4, my lord, I was supposed to, my lord, furnish a copy of my lord land documents that could not be obtained, my lord. My lord, Lordship will kindly allow me to withdraw both these petitions, my lord, with the liberty to file afresh. Because, my lord, certain documents could not be obtained, my lord.
Okay.
So far as the linkage,
Says item 4, both sides are represented. Mr. Zaid Ahmad, counsel for the petitioner, submits that some documents were left out and not filed in the along with the writ petition. So accordingly, he praised, permit him to withdraw the petition and to approach the court again. So prayer is allowed. Matter stand dismissed on withdrawal with liberty as paid for.
item 4 and 11, my lord. I'm deeply obliged.
11 is
11 is also, my lord, the shortage of linkage is there. Therefore, my lord,
Same.
land documents, my lord.
six.
Yes, my lord. I'm deeply obliged.
May I please, Lordship? Lordship, I beg to mention item number 38 and 39, Lordship. Both the petitioners are in detention, Lordship. Kindly, matter might be updated, Lordship. Kindly, Lordship, otherwise, it's not good, Lordship. 38 and 39, roughly.
Yeah.
These are motion matters. It will come serially. We can't help it.
Lordship.
Okay.
May it be pleased, your lordship. Lordship, I beg to mention item number 12, lordship. Matter may be passed over for the day, lordship.
It goes after vacation.
No, lordship, immediately after vacation. Matter, date may be fixed, lordship.
Item 12,
Yes, lordship.
list in the motion column after ensuing vacation as prayed for by learned counsel for the petitioner. Item 12,
Yes, lordship. Date may be fixed,
it
lordship.
will come.
Problem.
If not, make a mention.
Daily list item 1 for motion.
We'll take up orders first. Hmm? Give us call for that. Orders please. All IAs, only for IA.
Only for IN miss case.
IN business.
Item 25 for orders.
May I please? My lord, I may be allowed to do this petition with the liberty to file a petition.
Why liberty?
My lord, I want to file a fresh, my lord.
Both sides are represented. Yes. We don't understand. Do you want to withdraw it?
My lord.
It is already dismissed.
Not with the liberty, my lord.
No, dismiss matter, what liberty will give? Please tell us. It's already dismissed. You have filed a miscase for restoration.
My lord, the reasons for which I could not appear before the learned court, my lord, that I could not explain it properly, my lord. That is why.
No, that we don't know. A dismiss matter, what is there to withdraw? How can a dismiss matter be allowed to be withdrawn? Tell us.
You want to withdraw the IA?
No, yes, my lord, miss case.
Miss case, you want to miss case.
Miss case.
Tell us.
Withdraw the miss case.
Okay. Mr. J. Islam, learned counsel for the petitioner, seeks to withdraw this, in this case, with liberty to file again. There is a lot of matters dismissed on, in this case, stand dismissed from withdraw with liberty as grateful. All the respondents are represented.
Published.
26,
Twenty-six, read appeal, sir. 26, nine. It will read appeal.
item 27,
I'm sorry, madam.
Yes.
My lord, in fact, the service is complete on the private respondents, my lord. I have filed a affidavit
No,
also.
that we have adjourned it for some time. But this is a regular rate appeal.
My lord.
We are taking up IAs in the foreigner tribunal matters first.
I'm sorry.
He's appearing in item number
He's appearing
26.
26.
You're appearing in 26.
My lord,
Which
Yeah.
item number?
I have to see, man. My
26.
petitioner's name is Abul Hassan, man.
That's a
26.
writ appeal.
Read appeal.
That we are not taking up. We are
Madam.
only taking up the
Foreigners
foreigners
matters.
matter.
Sorry,
with
I'm
the-
sorry, man.
Yeah. 27. So, the bail or. It's for bail. Thank you.
And the
28,
Mr. Hassan, you're wearing? In the middle.
but you know, counsel for the petitioner.
Item 28.
applicant. Also heard Mr. G. Sharma, learned standing also for the FT. Matters representing opposite party numbers 2 and 6. Mr. Sharma, learned government advocate appearing for respondent number 5.
Miss M Lady on behalf of P Boria for number 3.
Is M.
M
Lady.
Lady on behalf of
and counsel appearing on behalf of
MSP Burua,
Ms.
SC
Barwa,
ECI.
learned standing also for respondent number 3. Next, this interlocutory application has been filed for insertion of the case number in conjunction with who is the connected The petition has been filed. Next one. Next, here is allowed. Next one, it is clarified that the order dated 38/2024 passed in WPC 1303 of 2024 is in connection with the challenge made to the order dated, sorry, opinion dated 21/11/2023 passed by the Foreigners Tribunal, Borpeta 11th, Borpeta, in case number, begin bracket, capital B, small pt, oblique 11th, bracket closed, FT 1524 of 2017. Stop. Next, accordingly, this order shall be read together with order dated 38/2024 passed by this court in WBC 1303 of 2024. Next one. Next one. Resultantly, the time for the petitioner to appear before the Superintendent of Police, within bracket Borpeta, border, bracket close Borpeta, in terms of the aforesaid order dated 38/2024, stands extended till 14/10/2024. Next, this interrogative application stands disposed of.
Obviously, Your Honor.
What order I say? Nothing.
Item 29.
It will go, huh? The petition. The petition.
This is for modification of order. Lord.
Yes, yes. Okay. Now the present call for the applicant. Mr. G. Sharma, the next standing counsel for the applicant. All these three names, Mr. Sharma and. Next, para. This interlocutory application has been filed for modification of the order dated 28/8/2024, passed in WBC 4283 of 2024. Next, by the said order. Direction was issued to for the petitioner to appear before the Superintendent of Police within bracket border, bracket was Bajali. It is projected that the case records in respect of the applicant is lying with the with the office of the Superintendent of Police within bracket border, bracket was Borpeta. As the applicant is a resident of Borpeta district. Next one, accordingly, the prayer made in this interrogatory application stands allowed. The next one, the directions contained in the order dated 28/8/2024, passed by this court in WBC 4283 of 2024. Shall be read as if directing, sorry, directing the petitioner to appear before the action containing paragraph 5 and 6. For the petitioner to appear before the Superintendent of Police within bracket border, Vijali. Shall now be shall stand modified, and the petitioner is directed to appear before the Superintendent of Police within bracket border. In that was Borpeta. Next, the other. Next, part, the actions contained paragraph 5 and 6 of the said order dated 28/8/2024. Stand modified to the extent as indicated above. Next paragraph. The next one, the time for the time granted to the petitioner to appear before the Superintendent of Police within bracket border, Borpeta, is extended till 14/10/2024. So this interrogatory application stands disposed of. This order shall be read together with so and so. This order shall be read together with order dated so and so, passed in so and so.
Item 27.
May I give you, my lord, this IA has been filed for, my lord, granting bail to the petitioner.
Bill will take up later. Because this is, we are taking up all those orders for correction of the orders.
My lord.
Those IS we are updating up. Because this will require some amount of, some length of hearing.
Now, only, my lord, in the impugn order, my lord, it has been held, my lord. The petitioner has failed to prove the linkage.
No, that's okay, but we'll take it up after some time.
After some.
After the motions, we'll take it up because
Well-
now we are taking up those matters which,
Yes.
where our orders are required to be corrected.
Extension of time. my lord.
Obliged. Take it up after some time,
Well-
some matter.
LCR is received lordship, if possible lordship, fix the matter after vacation lordship.
No, he's asking for bail. We
Yes,
can't postpone it like that.
Item 30.
May I please, your lordship? My lord, in the order, my lord, it would be Borpeta instead of Bozali. Page, my lord, 10, para 6.
What is the district?
District, my lord, Borpeta. Borpeta. And in the order, my lord, is reflected Bozali.
The order is passed by Tribunal of Bozali.
Bozali. But his, my lord, address is falls under the Borpeta district. And therefore, the direction was given to Bozali.
Better to modify and come back on Friday or something.
Yeah, that's true. Executive.
Hmm.
Page 6. Mr. Sharma, can you verify it will take it up day after tomorrow?
Yes, Lordship.
Whether his records are in Borpeta or Bozali,
Yes, Lord.
page 6, paragraph 4, he has said.
Lord.
Give me the application.
You have not served an application.
Sir, your lordship, I mean,
In the middle, he has said, hence the record of petitioner case is available in Superintendent of Police Borpeta.
District to
Borpeta. Trial to list Bozali. List to enter the public.
Yes, Lordship.
Please make an invite. We'll take it up on Thursday.
Yes, Lord.
Mr. S. A. Ahmed, learned counsel for the petitioner, submits that the petitioner is a resident of the district of Borpeta, and therefore he has made a statement in paragraph 4 of this interlocutory application, project that that during trial, Bajali district was bifurcated from Borpeta, and the address of the petitioner falls under Borpeta district, and hence the record of the petitioner's case is available with the Superintendent of Police within bracket border, bracket close Borpeta. Next, Mr. G. Sharma, and standing counsel for the FT matters, shall ascertain the correctness of the said.
Yes.
She shall make inquiry
Yes,
and inform the court accordingly as per list on 3/10/2024. Obtain instructions. G. Sharma shall obtain instructions. Give a copy, extra copy
Yes,
to
my
him.
lord, I will serve.
Item 31.
Item 31 is the same, Lordship. I have taken the instruction. It fall under Borpeta district, Lordship.
Borpeta.
Already.
Okay.
My lord, in IA, my lord, 3056, Deputy Superintendent of Police Bozali already referred the matter to the, my lord,
Heard.
Borpeta. Case 1-3, my lord. The
Heard.
case is clear, man.
Mr. H. Ali, learned counsel for the applicant. Also heard same names. Next, this interlocutory application has been filed for modification of the order dated 6/5/2024 to the extent that the applicant be permitted to appear before the Superintendent of Police within bracket border, bracket close, Borpeta, instead of Superintendent of Police within bracket border, bracket close, Bajali. And for extension of time to appear for bail before the said authority. Next one. The learned standing counsel for the FT matters has submitted that he has received instructions that the records are available with the Superintendent of Police within bracket border, bracket close, Borpeta. Next paragraph. The petitioner also relies on a communication dated 27/5/2024 within bracket annexure 2. Was it that the address of the petitioner falls under Borpeta district? Next paragraph. Accordingly, this application stands allowed. Next paragraph. The directions contained in in paragraph 7 to 10 of the order dated 6/5/2024 passed in WPC 671 of 2024 stands modified by substituting the Superintendent of Police within bracket border, bracket close, Bajali, to Superintendent of Police within bracket border, Borpeta. Accordingly, it shall be construed that the petition shall appear before the Superintendent of Police within bracket border, bracket close, Borpeta, and obtain bail in terms of order dated 6/5/2024. Next paragraph. Accordingly, we also extend time for the petitioner to appear before the Superintendent of Police within bracket border, bracket close, Borpeta, till 14/10/2024. Next paragraph. This order shall be read together with order dated 6/5/2024, passed in WBC 671 of 2024. Next paragraph. This interlocutory application stands disposed of.
Next one, I for impediment mallet. Next, I for impediment mallet.
Which IA? There is another IA.
3060. SP Borpeta and DC Borpeta for impediment mallet.
As respondent number
7 and 8 mallet.
7 and 8. Heard this one. This interlocutory application has been filed for impeding the District Commissioner from Borpeta and the Superintendent of Police within bracket border, bracket close, Borpeta, as respondent numbers 7 and 8 in the connected writ petition. Next paragraph. The learned counsel for the petitioner submits that after bifurcation, same paragraph. Next paragraph. The learned standing counsel for the FT matters has submitted that he has received instructions from the Superintendent of Police within bracket border, bracket close, Borpeta, that the records are available with their office. Next, accordingly, this interlocutory application stands allowed. The District Commissioner, the petitioner is, the applicant is permitted to impede the District Commissioner, Borpeta, as well as the Superintendent of Police within bracket border, bracket close Borpeta, has responded numbers 7 and 8 in the connected rate petition. By providing freshly typed cost title to the AOJ within bracket civil rule pending section for incorporation in the connected WPC 671 of 2024. Next, probably, let the matter be listed, and thereafter is the said petition in court. Next para. This interlocutory application stands allowed.
Item 32.
Wait.
Hmm.
Second.
Mr. Sharma, is it possible to get information today? No,
Lordship,
make an attempt. It
Yes,
can be,
Lordship.
because the petitioner is projecting here that she appeared before the Superintendent of Police, gave the order, and they said it was COVID, so therefore no need for other formalities.
Yes,
She was allowed to go home.
Lordship.
So the Superintendent of Police will have to search for this file. If the order of the court is available there,
Lordship.
the page 10 order. This is the order dated 22/12/2021. Passed in WPC 5838 of 2019. Just make a note. Order dated 22/12/2021. Passed in WPC 5838 of 2019.
WPC?
Yes, because she was granted bail.
Yes, Lord.
She says that she went to the police, Superintendent of Police. It was COVID that time,
Yes, Lordship.
so therefore she was allowed to go. This,
Lordship.
if this order is available in the file, that means she has gone there.
Yes, Lord.
We want to check that. We will take it up at 2.
Yes, Lord. Okay.
Supplementary item 41 for orders.
May please, your lordship. My lord, in this case, my lord, the present applicant and their parents were in the proceeding, and the parents have in the meantime died, but after hearing the parties, this honorable court has found that the proceeding was initiated by an inquiry only against the father. Therefore, this honorable court has disposed of the writ appeal, allowing the petitioner to appear before the Superintendent Police Nagaon. And there was some delay in approaching, and they to get the message, my lord. The disposal lordship may kindly have a look at paragraph 18 of the judgment at page 19. In the light of the Sudhir case, this case has been closed to the view that the findings of the tribunal will not operate against these people because there was no inquiry against them, and they are allowed to appear before the tribunal, before the border SP Nagaon within a time, my lord. That was failed, my lord. Some delay was because the phone number they have given, my lord, they did not work and could not reach the contact number, and by way of messenger, message was given, and they have collect the order, but in the meantime delay has caused 11-day delays, my lord. My lord, the operative person, my lord, paragraph 18, 20, and 21. My lord. Then, my lord, my lord, 22 also. 22 is the last, my lord, operative person. Accordingly, we close the writ appeal at this stage by making it clear the findings of the tribunal by order dated 1/2/2010 in case of application number so and so, which is upheld by the learned single judge in the order dated so and so, passed in petition number so and so, will not operate against the appellant number 327 till an inquiry is made by the state authorities, and in the event they are called upon to appear before any competent tribunal pursuant to any reference that may be made by the state authorities. The said appellants will be at liberty to file their representation and place all the evidence as feel necessary in support of their defense. As such, the finding of the foreigners tribunal Morigao against the family members will not operate as a bar to discharge their burden under Section 9 of the Foreigners Act 1946. In the event the state decides to make any reference against them. However, it is directed that the benefit of this order will accrue to the appellant number 327 only if they appear before the Superintendent Police Border Morigao within a period of 15 days from the date and the Superintendent Police Border Morigao upon the appearance, the appellant number 327 within the period indicated above will record obtain biometrics of their iris of both the eyes, the fingerprints of both the hands, and the photographs of the appellant number 327. On their appearance before the Superintendent Police Border Morigao as directed above, the state authorities shall also obtain necessary information and documentation as required under the rules from the appellants. Well, this was the order, my lord. This was order on 4/28/2024 and directed to appear on 4/9. The phone number did not work, my lord, then send messenger, then they receive the message, then come and collect the order. In the meantime, 11 days delay, my lord.
Let them appear before the authorities within 1 week.
Yes, my lord.
Yes, Mr. Sharma.
Let me go and appear.
Heard. The council of the parties. This IA has been filed. Praying for extension of time to comply with the direction of this court. Passed. by the order dated 2008-2024 in WPC, writ appeal number 49 of 2020. So, by the said order, the writ appeal was closed with a direction to the appellants number 327. It was closed, directing that the order passed by the tribunal dated 1/2/2010 in FT case number C 324 of 2006, as well as the order passed by the learned single judge by the order dated 11/9/2015 passed in WPC number 2128 of 2010 will not operate against the appellants number 327 till the inquiry as directed is made by the state authorities. Stop. In the event they called upon to appear before any competent tribunal pursuant to any reference made by the state authorities, the applicants will be at liberty to file their representations and place all evidences as felt necessary in support of their defense. So it was held that the findings of the foreigners tribunal within bracket first Morrigaon against the family members will not operate as a bar to discharge their burden under Section 9 of the Foreigners Act 1946 in the event the state decides to make any reference against them. Stop. This court further directed that the benefit of this order will accrue to the appellants number 327 only if they appear before the Superintendent of Police Border, Morrigaon, within a period of 15 days from the date of the order, and upon their appearance before the SP Border, Morrigaon, the biometrics of iris of both the eyes, fingerprints, and photographs, etc., will be recorded, including necessary information and documentation as required under the rules for securing their presence wherever necessary. So, better. Learned counsel appearing for the applicant submits that the applicants were the appellants 327 in the writ appeal number 49 of 2020, which was disposed of by order dated 2008-24. Stop. Learned counsel for the applicant submits that because of failure to be communicated in due time about the order dated 2008-2024. The applicants could not appear before the SP Border, Morrigaon, within the time frame prescribed in the order dated so and so, passed in writ appeal so and so. Stop. It is submitted that because of failure to be apprised or informed about the order due to failure of phone connection, there was a delay of 11 days. Stop. Learned counsel for the applicant submits that under these circumstances, the present IA has been filed, praying for extension of further time. Counsel for the respondents do not object to the prayer made. Directed to appear before the SP border in terms of the order dated so and so, fast in appeal so and so. Within 14/10/2024. Stop. The other conditions contained in the order dated so and so, more particularly the conditions in para 22, will remain the same. Stop. This order shall be read together along with the order dated 2008/2024, passed in written bill number so and so. I accordingly stands disposed of, allowed and disposed of.
Supply item 42.
May I please your lordships? We filed this IA seeking extension of time period to appear before the superintendent matters. The applicant has been on interim bail since 19/12/2017. But the matter was again listed on 27/5/2024, when a junior counsel had appeared seeking time since the senior counsel was not present. But this honorable court passed an order directing the applicant to appear before the superintendent on or before 18/6/2024, failing which she shall be taken into custody. My lord, there was some miscommunication between the junior and the senior counsel, my lords. And senior counsel came to know about this order only on 8/9/2024. Therefore, some time may be extended so that the applicant can appear before the superintendent.
Has she been taken into custody now?
No, ma'am. Not.
You have to appear. It is being reflected. But you are not on bail.
Yes. Yeah.
No, but the direction, the basis is automatic elections.
Okay, your name?
K. Burman.
K.
Burman.
Ms. K. Burman, I'm counsel for the petitioner. Also heard Mr. G. Sharma, then standing counsel for the FT. Mr. A.I. Ali, standing counsel for the ECI, and Mr. Sharma, Leonard, government advocate appearing for the state respondent number 4. Next paragraph. The learned counsel for the applicant has submitted that there was some communication gap between the counsel who had previously appeared in the matter on 27/5/2024 and the counsel holding the brief for the applicant. And accordingly, due to communication gap, the applicant could not appear before could not be informed about the requirement to appear before the superintendent of police within bracket border within bracket coast, Borpeta, and to take bail within 18/6/2024. So it is projected that the said order came to the notice only on 9/9/2024 and the learned counsel for the applicant send a letter dated 10/9/2024 to the applicant. And accordingly, this interlocutory has been filed, application has been filed for seeking extension of time to appear before the superintendent of police within bracket border, bracket was Borpeta, in compliance of the order dated 27/5/2024, passed in WBC 7922 of 2017. Next, Mr. Sharma, we extend the time.
Yes, Lord.
Next. In view of the explanation tendered, this court is inclined to extend time till 14/10/2024 to appear before the superintendent of police within bracket border, bracket close Borpeta, in compliance of the order dated 27/5/2024. And to take bail as directed. The other conditions contained in the order dated 27/5/2024 shall remain the same. Next program. Accordingly, this interlocuting application stands allowed and disposed of. Next program. This order shall be, before that you write, this order shall be read together with order dated 27/5/2024, passed by this court in WPC 7922 of 2017. 1410.
Yes, obliged.
Next.
Daily list item 1 for motion.
Progress challenge the impugned judgment dated 27/7/2009. Lordship, the petitioner earlier two occasions he is declared as a foreigner by Hosai Tribunal.
This is the third proceeding.
Lordship,
This is the third time.
yes, Lordship.
There were two proceedings earlier.
Yes, Lordship, before the Foreigners Tribunal of Hosai Lordship, they are declared he is a foreigner, not foreigner, he is not a foreigner. Annex 3A, page number 22, Lordship.
It is second proceeding.
The earlier orders were not produced before the tribunal.
Lordship,
There were two orders in your favor.
Yes, Lordship.
Was it placed before the tribunal in the order which you are challenging now?
Mr. Sharma, we are staying it. This the impugn order, we are inclined to stay this order.
Lordship.
Twice he has been declared not a foreigner.
Yes, Lordship.
And in the present opinion, this exhibit 9 and 9A is not even discussed.
Yes.
Page 13, paragraph 9. Not
Yes,
even
Lordship.
discussed.
Not discussed, Lordship.
We are staying this operation of this opinion.
Yes, Lordship.
Heard, miss,
No.
your name?
CM Decca Lordship. CM Decca Lordship.
CM Decca,
Yes, Lordship.
learned counsel for the petitioner. None appears on call for the respondent numbers 1 and 6. Heard Mr. G. Sharma, done as standing counsel for the FT matters, representing respondent number 2 and 6. Mr. A.I. Adil, done standing counsel for the Election Commission of India, representing respondent number 3. And Mr. P. N. Sharma, done government advocate appearing for respondent number 5. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 27/7/2019, passed by the learned member, Foreigners Tribunal number 1st, 1 ST, Hojai, Shankardev Nagar, in capital FT, /H, case number 204 of 2015, arising out of SP reference case number 197 of 2015, page 2. So by the impugned opinion, the petitioner was declared to be a foreigner of post 25/3/1971 stream. And the deportation of the petitioner was ordered. Next paragraph. Issue notice returnable in 4 weeks. Requisite extra copies of the resolution be served on the DSGI as well as the government advocate and standing counsel for the respondents within 2 days. Next one, the learned counsel for the petitioner has prayed for interim relief and for bail, which is opposed by the learned standing counsel for the FT. Next one. from the documents appended to this writ petition, it is noticed that the petitioner had furnished copy of opinion dated 7/9/2015 passed by the member, Foreigners Tribunal, Hojai, Shankardev Nagar, in case number capital FT /H /744/2012, as well as opinion dated 13/10/2017, passed by the member, Foreigners Tribunal, Hojai, Shankardev Nagar, in case number capital FT /H /1766/2012, which were exhibited as Exhibit 9 and Exhibit 9 within bracket A. In the present proceedings, which is the third proceedings against the petitioner, and in both the said opinion, and as per both opinion, the petitioner is adjudged as a, not adjudged, you say, is opined to be not a foreigner. However, in the impugned opinion dated 27/9/2019, the member, Foreigners Tribunal, Hojai, Shankardev Nagar, has not discussed about Exhibit 9 and Exhibit 9 within bracket A, being the previous opinion of the same tribunal. Next, accordingly, the operation of the opinion dated 27/9/2019, passed by the member, Foreigners Tribunal, Hojai, Shankardev Nagar, in case in FT /H case number 204/2015, arising out of SP's reference number 197/2015, shall remain state. Next para. Pending examination of the records, court is inclined to grant bail to the petitioner by providing that the petitioner shall appear before the Superintendent of Police, give same order, 5,000 rupees, to the satisfaction of the SP, Superintendent of Police within bracket border, Hojai. That he shall appear before the Superintendent of Police of Hojai within 14/10/2024. Next, list the matter on receipt of the records from the tribunal. You have to take bail within 14th. You have to take bail within 14th.
By 14 October.
You have to take bail by 14th.
Yes.
Item 2.
Highly opposed. May I please, your lordship, the engaged person is J. A. Ahmed, your lordship, he's outstation, your lordship. For medical treatment, your lordship.
Okay, it goes after vacation then.
Yes, your lordship.
Okay.
The brief is between
It is-
him, your lordship.
Both sides are represented. On the ground that the council only the brief is out of station on medical grounds. All the matter stands adjourned today. List in the motion column after ensuing vacation.
Obliged. your lordship.
Item 3,
Make little lordship. Lordship contested matter lordship. Lordship impung open on page 75 lordship. Impung open on page 75 lordship. Other already examined. Kazi already examined my lord. Yes.
Lordship. 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 Yes. Lordship.
Does the petitioner have any voter list with Abdul Ghaffur?
Lordship, she has to establish her link with Lordship Abdul Sattar Ali Sikdar, Lordship.
No, no. You see, there's an opinion at page 47.
Yes, Lordship.
We are trying to have a connect with this, even this man. Is there any voters list together? That is the only question we are asking. Is there any voter list? You have understood or not understood us?
My voter list is not there, ma'am. This voter list not annexed in this case.
নহয় এই মানুহজনৰ লগত আছে নে? আব্দুল গফুৰৰ লগত।
Abdul Ghaffur, my lord, kindly see page number
Okay, we'll call for the
36, my
records.
lord.
We are asking a question and it's a very specific question. Out of all these 100 pages, we are asking only one question. We're not asking you 10 questions. We are asking you on these 100 pages only one question.
My lord, kindly see page 36, my lord.
We
Abdul,
are asking you a question. We don't want to go anywhere else. We are asking you one question. Please respond to it. If you have understood the question, because I have repeated twice or thrice. If you have not understood, we'll explain you once more. But when you ask you a question, you respond to that only. Please. This is item
3, my lord.
We are confident records.
Yes.
Your name?
M. Hawk.
M.
Hawk.
Mr. M. Hawk, you are counsel for the petitioner. Also heard Mr. G. Sharma, standing counsel for the FT matters. Miss M.
And Bedi.
And Devi.
S. Bedi.
M. Bedi.
Bedi on behalf of
M.
P.
Bedi, counsel appearing on behalf of Mr.
Miss P. Purva.
Ms. P. Barwa, standing counsel for the Election Commission of India, and Mr. P. N. Sharma, and government advocate appearing for respondent before. Next, para. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 28/3/2024, passed by so page 1. Next, para, before issuance of notice, the court is inclined to examine the records. So accordingly, let the records of the proceedings of FT case number that you will find in this page 1. So and so from the member foreigners tribunal number 4th Gwalpara. Next, in the meanwhile, the petitioner shall provide additional copies of the petition to the learned DSGI as well as the learned state and departmental counsel in course of the day. Next, subject to compliance of above directions, comma. You pass the same orders for bail. Standard format. Bail, sum of rupees 5,000 with to the satisfaction of the superintendent of police within bracket border, that it goes Gwalpara. For which the petitioner shall appear before the said authority within 14/10/2024. We'll have those conditions, IDs of eyes and all, those conditions will be there.
This one.
You can put it here. Mhm. Mhm. Okay. List after 4 weeks. List after 4 weeks. Rush.
Item
चलो ये तो काम ना करो.
ঠান্ডা আইলে বহুত আহিব ন।
item 5.
the.
Item 6.
My lord, my senior is in another report. Ask for time.
Item 7.
Right, your lordship. Lordship, it is a contested case.
Why this delay 21 matter you have come now?
Lordship, there is some delay, lordship. I have stated in the para 22, lordship. I'm a poor lady, getting some, managing some cost to the petition. I have contacted my advocate, so delay may be calmed down, lordship, on that aspect. Linkage, lordship, Gabra certificate and notation order. Gabra certificate annexure 9, notation order annexure 10.
Action 9 and
Alternate-
10, page.
Gabra certificate, page number 50, annexure 9.
You see that everything goes away. You are come to page 34.
Yes, Shahjaman, Gabra, Shahjaman.
So you see, you cannot say when she was married. There goes his certificate.
He has given that certificate, seeing the voter list of 1997.
No, but you see,
As stated by
he has
brother.
said that as stated by the brother of OP, I have given the certificate.
Yes, some certificate may produce, certificate have produced by her brother, lordship. And also she has, Gabra gave the certificate depending upon the voter list of 1997. And he cannot say exactly on what date she has married, lordship. She was married, lordship. But he said that she is a resident of Nisuka Gapanchayat. And
No, you see, we have to have some link with any person who is there in India before 25/3/1971. So how do you connect with your parents?
that can be found annexure 6, page number
Page.
44, voter list of 1966.
44.
44, page number 44. Here his father's name, oh sorry, her father's name Abdul Samad Ali Mia and mother Samiran Nessa, alias Misiran Nessa. Misiran Nessa and Samiran Nessa, both her mother's name, lordship.
You come to page 42,
42.
third paragraph.
Yeah. From the evidence adduced by DW's independent proceeding, claimed that Ahmad Ali Mia, whose name appeared in the voter list to be her father, but there is not an admission document or evidence to prove the linkage of process. So I have used the Gabra certificate, Lordship, proof linkage, and also a mutation order, Lordship, page number 51 to 55, relevant page is 52. In the 2019, 2018 order of the circle officer, Lordship. 16/8/2018 order of circle officer, Lordship.
Page
Page 52, right
52.
side, the first para. চক্ৰ বিষয়াৰ 16/8/2018 তাৰিখৰ নামজাৰি নম্বৰ ইমান হুকুম মৰ্মে 1021 দাগৰ মাটি উত্তৰাধিকাৰী সূত্ৰে শ্ৰী চামাদৰ স্থলত মিচিৰণ নেচা her mother পতি মৃত আব্দুল সামাদ আৰু আসগৰ আলী পিতা মৃত আব্দুল সামাদ. Asghar Ali is her brother. Abdul Ali also is her brother. Rabia Khatun, her sister.
Where is the original entry of your father? Serial number? In this Jamabandi page 52,
52.
where is the father's name with serial number of column 3?
Column 3. I'm reading from the column Montebbo, column 10.
No, I am asking from serial number 3. Column 3. Where is the name of your father? Against which entry this 2018 entry was made?
I have only this portion, Lordship.
No, I understand. This remark will arise
It should be
from
other pages
the
also.
corresponding entry at serial number 3 of the Jamabandi. There some name must be there, and out of that name, some name has been struck off. And mutation has been done. So which is that entry, particular entry, serial number?
It's not here, Lordship.
Have it found here.
What is the name of your father?
Father Abdul Samad Ali Mia.
Samadadi Mia.
As circle officer order is here, Lordship, the name also must be there.
No, but we are not finding that name. That's why we are asking you.
Yes. I'm getting, Lordship.
You must identify with some entry.
Our brothers and sisters' names are only in the page number 53. I am saying this. But father's name I cannot find.
There is no Samad Ali Mia here.
His
Serial number
her
1 is
father's name is Samad Ali Mia, but in here, circle officer's order, it is only stated that Sri Samador Stholot, Misiron Nesa, Poti Mito Abdul Samad.
okay. That's okay. Then
Yes.
find out Samad.
Yes.
Where is that Samad?
এইটো ধৰিব পাইছে নেকি? এইটো চাওকচোন। কাটি দিছে যে, Samad নেকি? ডাঙৰ কৰি চাওক।
By 2 o'clock, get a better copy. You just read, tell us the name.
But
Because
it is strike, Lordship. Maybe it is Samad, number 2.
Serial number.
Hmm.
What is the serial number?
Not look like Samad, Lordship.
no, please identify we are just wanting you to identify the name in lieu of which these names have come in. Some name has to be struck off after death. So which name was struck off? Because we just want to identify the name of your father.
Photo something, photo Samad.
You have the original document with you, no?
Some names are cut, so it is not visible.
Can't read.
Can't read, Lordship. It is illegible to read.
Some certified copy lordship, he could not able to read lordship.
No, it is so small, Lordship,
Your documents.
provided by the authority, Lordship. Also, Lordship, DW2, her brother deposed before the tribunal. Gabra also deposed before the tribunal. না বুজি পালো মই পিছৰখিনি কৈছো
Grandfather's name?
Lordship,
What is your grandfather's name?
grandfather's name Nawab Ali. Nawab. Nawab is here. Nawab. But as father, Lordship, serial number 2, Pita Nawab.
The name?
Some name, one name is there, which is cut, but as son of Nawab.
First we can, we've been able to read.
So his name also must be there, Lordship, as he is also the son of Nawab.
Samad.
Number 2 is look like Samad, Lordship, Abdul Samad, but it is so badly cut, so it cannot be legible.
So we are taking a short break. In the meantime, you take your mobile, take a photograph, charge it. That's what we have done, but we can't read, still we can't read that name.
One-
Still because
It seems like Nawab.
we are not finding it. We are not able to identify the name.
Number 2, it seems like Abdul Samad as badly cut.
Or you
So-
get a certified copy.
Only take a file, take a photograph of the mobile, take it from your mobile, enlarge it, try to read it. That is why my brothers like to read through to help you, but it will check it out. Please do it. Because what name of this struck we are able to find. Take a rest, take for some time, we see it. You can check out this name.
Not sure, I take a photo from my mobile. I can see it as Abdul Samad. When yes, Fatima, look at this. Can have a quiz or something. Can have a quiz.
They're taking a word for it.
Lordship.
We take our word for it, we issue notice. Let us examine the record.
Not sure. In the voter, in the MP in order, one voter list of 1997, which is a clear proof of linkage, that is also deposed before the tribunal. So the answer, when the answer comes, the petitioner may get letter interim relief, as the all total 9 documents are exhibited before the tribunal. So there are some clear proof of linkage. Lordship may see page number 39. Exhibit A to exhibit I.
Page,
39, Lordship.
yes.
Exhibit A to exhibit I. Exhibit I is the computerized certified voter list of
No,
1997.
you see, you are, this does not impress us because of the reason that your name with the projected father is not there in a common voter list. Is it there?
Yes, on the 1997 voter list, Lordship.
90?
97 voter list.
Which page?
I'm not annexed here. I can only I am going to the impugn order where page number 39, it is stated that computer certified voter list 1997 is
Okay.
before the tribunal,
Okay,
where Lordship may find it at page number 41.
okay. We are accepting it.
Yes.
Ms. T. Begum, learned counsel for the petitioner. Also heard Mr. G. Sharma, learned standing counsel for the FT matters. Ms. P. N. Bedi, learned counsel appearing on behalf of Ms. P. Barwa, standing counsel for the respondent number 5. And Mr. P. N. Sharma, learned government advocate appearing for respondent number 3. Mr. Sharma is for 2 and 4. None of his for respondent numbers 1 and 2.
Lordship, two and
Sorry,
four.
1 and 6. 1 and 6. 1 and 6 is not represented. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated page 2. If you notice, returnable in 4 weeks. Post of requisite extra copies of the writ petition be served on the learned DSGI and other and learned state and departmental council in course of the day. Next paragraph. Let the records of FT case number so and so page 2 be called from the member Foreigners Tribunal Borpeta number 8, Borpeta. Next paragraph. Heard both sides on the prayer for interim relief. First of all, the prayer for interim relief is opposed by the learned standing counsel for the FT matters. Next paragraph is the court is inclined to examine the records. The court is inclined to direct the petitioner to appear before the Superintendent of Police within bracket border, Borpeta, within 14/10/2024, and on her appearance and on furnishing a bail bond of ₹5,000 to the satisfaction of the Superintendent of Police, Border Borpeta. She is allowed to remain on bail. Those conditions will be there. Next, list the matter on receipt of the trial court records of the tribunal. Bail within 14th.
Safely obliged, Lordship.
Item 8,
Lordship, this is also a contested matter. Lordship may have a look. Annexure 12, page number 66. Earlier, he was declared as Indian.
You have
Why-
come after 3 years.
Yes, there is some delay,
Or-
Lordship.
4 years is not some delay. You are accepting only those delay matters.
Annexure 12. Page number 66.
But we don't find you've been able to connect you with your father.
Lordship, my
Is there any voters list with your mother and father together?
yes, mother with mother.
No, mother and father, both
Ma-
together.
Both together, no, Lordship. My
Then
mother, voter list of 1997, where Deep Wood has against my name, because my mother, after demise of my father, my mother, along with me, went to the paternal house of her. So my father's name, not in the voter list of 1997, but as the husband of Maziran is there. Page number 53. Page number 53, 441, serial number. House
there
number
is something wrong here. You see, in the cost title, you are referring to an opinion dated 3/11/2023.
Yes,
In paragraph 3, at page 5 of the writ petition, you are referring to an order passed in 2020.
Lordship,
Date is not there.
Lordship, Annexure 12. So I'm at the very outset, I have said Annexure 12, page number 66, where I am declared as Indian, Lordship.
Page 66.
Page 66 to 17. Page 66, Lordship. Mazibur Rahman, opposite party. I am this person, Mazibur Rahman.
You are now challenging which order?
I am now challenging 3/11/23, Lordship.
Page number?
Page number 39 to 46.
And what is the order at page 57?
Your page numbering is very inconvenient. We can't even find out your page number.
57. 57 is my brother's, Lordship. 57. He was also declared as an Indian, Lordship. 57. Who is deposed before a tribunal as DW3. Azahar Ali is my brother.
Earlier you were declared Indian.
Yes, Lordship. As per Annexure 12, page number 66, I am also declared as Indian, but this is second proceeding. I have stated in my writ petition, Lordship. Para 21, page number 10 in my writ petition. Hmm? So,
This order was placed.
yes, Lordship.
I think
What
not
is
less
the
Lordship.
discussion there? How these order has been?
This order, Lordship may find the impugned order at page number 39 to 46. Here, as exhibit G, page number 41, there are all total 7 documents are exhibited in the before the tribunal. Exhibit G is photocopy of judgment and order. But it is not discussed in the order, Lordship,
But in evidence, Lordship,
regarding that order.
In evidence,
Lordship, page 22. He placed exhibit A certified copy of voter list of 1966, 70, 1985, Gaubura certificate, Lordship, and GP certificate.
You're reading which page?
Page 22, Lordship, exhibited placed by the proceeding Lordship before the tribunal.
Thank you.
No, we are trying to find out from the discussion in the judgment, in the opinion. In the opinion, there's no discussion.
Discussion, yes, Lordship, no discussion. Exhibit F is discussed, but exhibit G is not discussed, Lordship.
G, what's it?
discussion,
No.
reference. But if the order is referred. So what judgment it is not disclosed.
So exhibit F, it is discussed, but exhibit
No, where is
G,
this exhibit G in your evidence on affidavit?
on which page, Lordship?
22.
In your evidence on affidavit, where is that document? DW3, where is DW3?
AW3 30, page number 32 to 38.
32 to 30,
From 32 to 38.
32 to
Yes,
38.
that's from 32.
Okay, where is this exhibit G, F and G? Okay, G is there, page 35.
That is his order, his brother's order.
Brother's order.
The
Exhibit F.
proceedings order is not there.
Yes, Lordship.
409.
But your order you have not placed.
Yes, Lordship.
Yes.
Even on WS, he is totally silent, Lordship.
I have placed only here, Lordship. On the subsequent case, Lordship, Foreigners Tribunal, it was not produced, Lordship,
Not produced.
not produced.
Can we discuss connected? Can we discuss connected? Page 45.
Right. 39, 39, 35. Elder brothers.
Hmm.
If he is produced.
Huh? That was the one of 15
Order, page number 16.
Zahar.
Tribunal order and given. That was not. And
No, not there.
your order is at page 66.
66,
This is the earlier order
earlier order,
by which you were declared to be an Indian.
Indian, Lordship.
This you did not place it before the tribunal.
That
Yes.
might happen, Lordship. That might happen, Lordship.
Then we are calling for the records at this stage.
Yes.
But
Lordship, interim relief may be considered, Lordship.
For the parties, this the petition is directed against the order dated 3/11/2023. Passed in case number FT within bracket fifth bracket close 4/31 of 2016 by the learned member Foreigners Tribunal Fifth Borpeta. Stop by the impugned order. The reference made by the state against the petitioner under the Foreigners Act 1946 was answered in the affirmative, and the petitioner was declared to be a foreigner of post 1971 stream. So, being agreed, the present we can apply. Whereas before proceeding further in the matter, this court would like to examine the tribunal reports pertaining to case number so and so. From the Foreigners Tribunal Fifth Borpeta. So registry will requisition the said reports and place it before the court. Your interim will examine after calling for the records.
Lordship, it seems that there is good ground to consider the interim relief, Lordship.
The best ground you did not urge that there is already an order in your favor was never urged. So the question now may arise is whether the person Majahar referred to in the earlier order and the present petitioner are one and the same person.
And the Azahar Ali, his brother and petitioner self, both orders may be called for. In the meantime, Lordship may consider interim relief.
In the meantime, petitioner will appear before SP Border. SP Border, Borpeta, within 10 days from today. And if a bail bond of rupees 5,000 is furnished, the petitioner will be permitted to remain on bail and not be deported out of the country without leave of this court. Stop. When the petitioner appears before the SP Border, the biometrics and fingerprints and other information regarding the residence and contact number we recorded. A similar order to sign off. This accordingly after 3 weeks.
Deeply obliged, Lordship. Lordship, can it be after some time? I have a prayer, my prayer, Lordship, may be considered. After some time, Lordship.
Item 9.
Yes. Obliged.
Item 10.
Lordships, you know that is at page 94, starting from 94, Lordship. By 82nd of Kamrup Metro, Lordship. Oh, one Metro. And
Where is the voters list of your grandfather and father?
grandfather and father voter list, Lordship, page 59, Lordship. Page 59 is of his father, Lordship. Sonaullah Sheikh, serial number 261. Grandfather Haisa alias Hassan, Lordship. Haisa. In the year 1966. And also in the year 1970, Lordship, page number 61. This is
Your father's name is
Sonaullah.
Sonaullah.
Yes, Lord. And my mother's name is Moziran Bibi. Moziran Bibi's name was included in the year 1970 Lordship. And that is at page 61 Lordship. Parents.
66, your father's name is there.
Yeah, Lordship. Yes.
Father and mother?
Mother in 70/71 Lordship. That is at page 61 Lordship. 1970. 1970, vernacular page 62 Lordship. From Mankachar LLC. Sonaullah Sheikh Moziran Bibi.
And your name with your parents?
My name unfortunately is not with my parent lordship because my mother died prior to my attaining the age of voting age. And my father solemnized second marriage with one Sahara Bibi lordship. So he started to reside separately lordship. That is at page 80. Voter list of 85 will show lordship. Page 65, that is Sonaullah and Sahara Khatun. This is my stepmother. My mother died. Thereafter, my father solemnized second marriage with one Sahara Khatun. And started to reside separately. In 85, my mother was in lordship, so he solemnized second marriage prior to death of my mother lordship. My mother's name is also in the voter list of 1985 from the same village in different house number. This is house number 53 and this is house number 60 lordship, page 67. My mother's name is there.
63.
Yes, lordship. 65 is with Sahara Khatun, Sonaullah with Sahara Khatun. 65. Voter list of 1985 lordship. Page 65. And at page 67, Moziran is single voter lordship against house number 60. At that time, the petitioner was minor lordship. And his mother's name. And in 89 also, Sonaullah and Sahara Khatun in house number 85. And the name of Moziran Bibi is in 95, house number, same village.
Where is the opinion?
Opinion is at page 94, starting from 94. And herein only the discussion, relevant discussion is at page 99 lordship. 99, 98 last paragraph may be seen lordship. DW2 is the father lordship. Sonaullah himself appeared before the tribunal and adduced evidence and he confirmed that the OP is his son. The last paragraph on so-and-so, DW2, Sonaullah Sheikh, identified as father of OP, adduced evidence. Name of his father is late Haisa Sheikh, mother so-and-so. He is about 72 years old. His parents. In this manner, he discussed the evidence of the DW2, learned member discussed. And the observation lordship, last paragraph of page 99 lordship. From exhibited document, it is seen that in 1966 voter list, name of opposite party projected father was enrolled from village Beravanga, Chor, part 1. In voter list 1970, 79, 85, 89, names of office projected parents were enrolled from village Beravanga, Chor, part 1 in Sirapur. And at page 100 lordship. Page 100, analyzing exhibited voter list, it is seen that opposite party could not connect his legacy with his present father. This is the reason, lordship. And the learned member stated that mere identifying by a person as father does not establish legacy. And there is no other discussion regarding the evidentiary value, etc. lordship. We did not discard even the evidence of DW2 lordship.
The only issue in this case is that the OP could not cast vote with his father. There is no document to show that he casted vote together with his father, but there is.
What is the evidentiary value of the voters list?
Voter list, Lordship, it's a documentary evidence, Lordship. It can be produced as secondary evidence. And it is,
No,
Lordship.
the tribunal's view is that you have produced a voter list identifying some person. But should there not be any collateral evidence to say that the person named in the voter list is the person before
Yes,
the
Lordship,
tribunal?
to prove this, the person Sonaullah himself appeared before the tribunal, Lordship.
But he says that he has, you see, he has got 8 children.
Lordship, his evidence
He
is.
himself has 5 siblings.
Yes,
None of them are together.
He, his name is recorded with his brother, Lordship, the OP Noor Hussain, the Noor Muhammad. These are at page 78 in the seen, Lordship, 2005 voter list. In the year 2005, his name was recorded for the first time, Lordship. Page 77. Therein, the name of his brother, Sheikh Noor Muhammad, is there, Lordship. He and his brother are staying
No,
together.
these are very common names. You see page 99, he says that DW says he had 8 siblings, 4 brothers, 4 sisters. Nobody is there together with the grandparents. Nobody's name is in a common family chart in the voters list.
In the voter list, Lordship, Sonaullah's name is there. Sonaullah and his other siblings.
You see, these are so common names that after every 20 cases, you will find the same names.
There is common name. This is admissible.
Then
Lordship, this is to be
So
admitted.
there-
That is, there is
there must be
similarity
some-
in
there must
name
be
of
some
the
persons in the family together. They're not together in the.
Here in Sabjan Bewa, son, wife of Haisa, page 59, Maneruddin Sheikh. This is son of Haisa, Sahara Khatun Bibi, Maneruddin. This is the elder brother of Sonaullah. And generally, what happens, Lordship, just prior to attaining majority they solemnize marriage and starts to live separately, Lordship. This is the regular phenomenon in the village, Lordship.
That is okay, but then
His father has appeared. The
connect in some manner.
Lordship,
Some collateral evidence.
collateral evidence, Lordship, there is a land revenue receipt is there, wherein Sonaullah Sheikh has paid land revenue for his son Nur Islam.
No Gaura certificate or anything?
Huh? Gaura's certificate was not admitted. There was a senior citizenship certificate, Lordship, senior citizen certificate in respect of Sonaullah. That was executed, Lordship, along with his electoral voter card.
Says Sonal
Lordship, I got the instruction, Lordship. Lordship, proceeding never appeared, Lordship. After declared foreigner, Lordship, even after Lordship getting the bail, Lordship. So, Lordship,
May I please, Your Lordship? Your Lordship, the Honorable Guwahati High Court was pleased to pass an order for not arresting the petitioner on 22nd of December 2021. Your Lordship,
There is no record of their appearance before the SP border.
Lordship, the petitioner appeared before the Superintendent of
no,
Police.
not appeared.
But at the time, that was the time of outbreak of COVID-19 third wave, Your Lordship. She was told that currently she is not needed to appear.
No, no, you see, what you did was incorrect. The High Court has granted you bail. You say that the Superintendent of Police asked you to go away. You should have taken a attendance slip signed by the Superintendent of Police. Now they are refusing to accept that you have appeared.
Lordship, there is another order, Lordship, 6822, Lordship.
See?
6822, Lordship.
Has-
So after passing of that order also, he did not appear, Lordship.
Read please.
Hmm. 060822.
See?
060822. Lordship order.
Ah.
Dated, passed by this honorable court, Lordship. And at that time, there was no COVID, Lordship.
So there is again a default.
Yes, Lord.
6822. Again, you were directed to remain on bail. Then it becomes a disobedience. It's not a case of non-compliance, it's a case of disobedience after that.
You have not mentioned about this order in your petition. You have not referred to this order in your IA.
Beg your pardon?
In the IA, you did not refer to the second order passed.
Yes, Your Lordship, I did not mention about it.
Then
Your Lordship, that was an interim order. I thought it was being repeated.
you should
The
read the
petition-
order. Read the order. Do you have a copy of that order?
Yes, I have read.
Have you read the order?
Yes, I have read.
Then you are asked to comply with the conditions by the second order also. We'll issue notice at this stage. Beyond that, we can't do anything. Heard learned counsel to the parties. Issue notice on this I returnable 4 weeks. Since Mr. G. Sharma and MS Bedi and Mr. Hazariga appears for respondent number 3, and 6, respondent 2, respondent 5 and respondent 6 respectively. Notices are waived. However, extra copies of the IA be served to the respective councils within the course of this week. respondents may file objections, if any. In the meantime, matter be listed after 3 weeks. AC2.
I'm being item 6 for motion.
Sorry, my lord, I could not turn off on the fast call, my lord. Here in this case, my lord, parents is voter in 1966 onward. Lordship may kindly have a look at case 31. 32 is the vernacular. Father's name is Mujibur Rahman. Monwara is the own mother. Petitioner has also stepmother. My lord, in 89 brutalist, petitioner with her father, with his father. Lordship may kindly have a look at the 66, 70 brutalist. Then my lord, 89 brutalist. 89 brutalist is with father and stepmother.
As per the opinion, you have not been able to connect with your parents.
My lord, I am voter with my parents, my lord.
Where is that?
My lord, Lordship may kindly have a look at page 37, total list of 89. The relevant portion at page 38. My father, Mujibur Rahman. My name is at serial number 164, Mustabizur. I'm voter with my parents.
You have different list, Lordship.
Mujibur Rahman is my father. Mujibur Rahman is my father. He is voter in 66, 70 onwards, my lord. And I am voter with my parents. Yes, my lord, my stepmother is appearing in 89 voter list. That has been pleaded facts.
Yes, Mr. Sharma.
Yes, Lordship, link is not established, Lordship. As Lordship will kindly see 1966 voter list Lordship of village Sapuri Lordship Mojibur Rahman son of Mokbul Hussain. Again, Lordship 1970 is same voter list Lordship.
Page number.
Page 31 Lordship. Page 31 vernacular, page 32. Here connected person's name is Mokbul Hussain Lordship. Then Lordship, after that there is no voter list Lordship. Again Lordship 1985. Lordship, it is of different village Ujiror Sir Lordship. Here Mojibur Rahman connected person name is not Mokbul Hussain Lordship. Some Mughal Hussain.
Preparing
Mughal
voter
Hussain.
list, what we can do, my lord?
Lordship. Mughal
Here,
Hussain,
which page number?
Page-
Page number?
page 35 Lordship. 1985 voter list. In between voter list are not there Lordship.
Then my brother's name is there, two stepmother is there.
Village is different,
Yes.
name
Everything is
different
also
Lordship.
stated facts, my lord.
Name
Meeting.
different Lordship.
Makbub.
Book.
What is the father's name?
My lord,
Earlier was
Mokbul.
Mokbul Hussain.
Actually, correct
And
name is
here is
Mokbul.
Mughal Hussain. Mughal.
Page number
Page 38 Lordship.
38.
38.
Or 36 also there is a chain.
Magub. Here also changing Lordship.
My lord, because of this variation, my lord, this situation, my lord. It is absolutely, my lord, sir, due to, my lord, wrong preparation of the voter list. For this, my lord, voter should not suffer. my lord.
What about any certificates? Any certificates issued?
My lord, he has examined his own brother. Certificate,
The school certificate?
my lord. School certificate is there, page 46, my lord,
Page?
46.
OCD himself is resident of village Tinkonia Para Lordship.
The shifting
It is also
there, shifting is
Again
there.
different village Lordship.
Here you are the son of Majibur.
Mujibur, yes, my lord, Mujibur Rahman. My father's name,
Majibur.
Mujibur, page 66, 70, lordship, 66, 70, 85, 89. Up to 89, my father was here, my lord. Father was surviving.
Okay, we'll call for the records. Then.
Mustafizur, most.
So, hmm. Third learned counsel for the parties. This petition is directed against the order dated 31/7/2024. Passed in FT case number. There are two FT cases.
Two case, my lord.
Why?
My lord. Two notice we have also annexed, my lord. Subsequently, both the cases were tagged
No, but you are filing a writ against which case?
My lord, this judgment is common, my lord.
Where was it clubbed?
My lord, that order will be available in the record, my lord. Two cases were there,
Separate.
but both the cases were tagged. Annexure 1 and 2, my lord, both the notice. In this judgment part also, that has been discussed, my lord. Two case.
ঠিক আছে, কিন্তু এখানে না বলতো। Renumbering. There are two. Issuing notice by
My
renumber.
lord, paragraph 8.
This is also.
In para 2, there is notice was issued only in one case.
My lord. My lord, Lordship, may kindly have a look at paragraph 8.
Para
Para 8 of the judgment.
8.
Two cases are being registered against proceeding and both are being taken together for trial. Paragraph 8 of the judgment. Page 80.
It is dropped.
My lord.
115 was dropped. So therefore, the opinion is only in respect of the first case.
Yes. But the in the into opinion contains both the order.
Very good. Practical purposes, the second. First case. Concept of an appeal. Right, right.
Because Mr. Sigdev,
My lord.
you see, technically, had it been a regular civil or a criminal matter, to challenge a common order, you'll have to file two appeals.
But here one is dropped, my lord. That order, paragraph 8 is that contains.
Para
Para 8, my lord.
8.
So, my lord, Soike has pointed out. One is dropped.
So.
Paragraph 8, my lord,
First case.
last but 3 line. As such, case number FTG4M115/18 is being dropped from the registration of list. So, ultimately, one case. And the both the case notice contains same charts. One in between 1/166 to 24 and 471.
You read this paragraph further?
My lord. Paragraph 8. On 15/5/2019.
No, not from there. After being dropped. You read
Yes,
thereafter.
my lord. Thereafter, on 6/10/2021, the Learned Counsel for the proceeding has filed a petition
Point number so to prepare for recalling the order decisions passed by the learned deceasor and to amalgamate the two references case and to proceed together in the further course of action. Peruse the entire case record and amalgamate both the reference case together in the future course of action. Hence, WS evidence, affidavit, cross-examination, argument, appoint both the reference case number so and so together.
So is it dropped or amalgamated?
No, it is ultimately amalgamated. Sorry.
Amend করবো না, এগুলোকে repetition করবো, ওটা হবে।
Mentioned it here, so. Impugned opinion dated so and so. Heard learned so and so, and counsel of the petitioner. Directed against the opinion dated so and so rendered in FT case number FT within bracket G-4 bracket close capital M/52/18 and FT case number FT within bracket G4 bracket close capital M/115/18. Stop. From a perusal of the impugned opinion, it appears that two references were initiated against the proceeding, namely the writ petitioner. Stop. Subsequently, both these references were amalgamated together and the proceedings were taken up. Proceedings in both the references were taken up together and the opinion impugned in the present writ petition was rendered. Stop. Before proceeding further, the court would like to examine the case records of these of FT case number so and so and so and so. Duta case. Stop. Let the records of the tribunal records of these cases be called for from the Foreigners Tribunal 4th, Gwalpara, Assam, by the registry. The matter be listed after 4 weeks. Stop. In the meantime, petitioner will appear before the SP order Gwalpara within 10 days from today. And if the petitioner is not already arrested in the meantime, shall furnish a bail bond of ₹5,000. Whereupon petitioner shall not be arrested, deported out of country in pursuance to the opinion dated so and so, passed in FT case number so and so, so and so. Stop. The petitioner's biometrics and fingerprints shall also be recorded along with all information regarding the residence and contact number of the petitioner. Matter be listed upon receipt of records as directed after 3 weeks. কিমান আছে motion? That's the center.
Time being item 9.
Right, your lordship. Yeah, it is also a contested case, lordship. Petitioner's own brother Fakhruddin, DW2, deposed before the tribunal. Petitioner's parents casted their votes.
2018 matter,
Lordship.
2018.
Lordship, it is impugned order dated 6/12/22, lordship.
Where is the impugned order?
Impugned order for 29 to 32, and extra 4.
Page number
29, lordship.
29. What is in page number 45?
45 is brothers. This is an order which was passed before the tribunal, lordship, where his brother was declared Indian.
What is the name of the brother?
Fakhruddin. Page number 45.
The finding is in 31.
His own brother, lordship. Another brother also declared Indian, lordship. In the WS it is stated. Para 24 of the page.
From where did the tribunal return the finding at serial number F, page number 32?
Page number 32. Exhibit 6 and 7, lordship. Exhibit 6, it is a certified copy of judgment and order delivered under the hand and seal of the learned member FTH, Borpeta and Factory case number 1, order dated 24/01/2018, declaring 1, Muhammad Fakhruddin, son of late Hussain Ali of village Surahari PS, that is not to be a foreigner. And exhibit 7 also, his own brother, one of his own brother, Habibur Rahman, also declared Indian, not to be a foreigner, lordship.
No, but see the finding of the tribunal at serial number F, page 32.
Page 32. In which para, Lordship? Different sets of parameters have been found associated with each of them separately. And besides, Office Mother, Khasta Khatun, wife of Hossein Ali, was 34. So he is 19. Her name is. In both of the cases, Lordship, same types of documents were produced before the tribunal, and tribunal ordered those findings, Lordship. My name is, I have casted both, Lordship. In the year of 1970, voter list of 1970, Annex 6, 35, 36. Lordship will find it 36. Where my name is along with my father, mother, and wife. Serial number 247. Hossein Ali is my father. 248. Khasta Khatun is my mother. Subhan Ali, 249 serial number. Petitioner self. Noorjahan Nessa is his wife. After that, Lordship, in 1975, voter list, here his mother, his name appeared with his mother and wife, and one of his brother also. Abdul Motleb Ali. He is dead now. In the voter list of 1985, petitioner with his brother Fakor. In the voter list of 1989, petitioner with his younger brother Fakor. And 97, voter list of 1997 also, petitioner with Fakhruddin, his own brother. Annexer 12, Lordship, Gawura also certifies that he is the son of Hossein Ali and living in that same address. Also a mutation order, Annexer 13, where his name appeared on behalf of his, in the place of his father. These are linkage documents. Okay. Yes, it was before the tribunal, SDW 2. Page number 25, Lordship.
No, this is his conclusion. None of the voters have been found residing in the state. Thereafter, 1970 for a period of 15 years. He'll be reappeared in 85 along with his wife, implying that the expansion went back. Yes, Mr. Sharma. Lordship, we have to say. Lordship. Anything to submit?
At this test, Lordship may call for the record, otherwise Lordship will kindly see the 1966 voter list test page 33. It is of different village, Lordship, Mini Simla, Lordship, and then Lordship 1970, Lordship, it is Poru Horit Lordship, yes. Village is different Lordship and some age discrepancy is also
From
there.
1970 to 85, where were you?
So that account, Lordship, I have shifted my father with his
There is no
family,
continuity Lordship.
Lordship, he shifted from village, Minisimla to Soruhari.
That is your statement.
Yes.
But how do you prove your existence in the state within that period? What is the basis?
70 voter lists shows my address.
From 70 to 85, that's what I'm saying. After 70 till 85, no presence.
25, Lordship.
Between after 70, there is 71 to 85 to 84. No presence.
1975 voter list there, Lordship.
75.
Yes, page number 37. My mother, with my mother, Lordship, I have
75, was it exhibited? Was not exhibited.
Not exhibited. Lordship.
75 was not exhibited.
59 to 30. Huh? 75, no.
In 1970, grandfather's names become mobile Lordship instead of
75.
Saba Ali Lordship. There age discrepancy is also there Lordship. Let the records come Lordship. At this stage.
Lordship, my exhibit 1 is 1966 voter list. Exhibit 2 is 1970. Exhibit 3 is electoral roll of 1985.
That is the finding of the tribunal. Between 70 and 85, no presence. You say 75 voter list is there, but it was never exhibited.
I'm annexed here, Lordship.
You have annexed, but it's not exhibited.
Not exhibited. I have annexed here.
Yes, heard. Learned counsel for this. You give your names to the court master. The cheat. The petition is directed against the order dated 6/12/2022. Passed in case number within bracket BPT/11th brackets FT 1647 of 2017 by the Foreigners Tribunal, Porpeta 11th. Stop. By the said opinion, the tribunal answered the reference made by the state in affirmative in favor of the state and against the proceeding. Stop the opinion. The tribunal opined that the proceedee could not prove that he came to Assam before 1/1/1966 or continued to reside in Assam as its ordinary resident during the period from 1970 to 1985, or that he was born in Assam during the relevant period, and consequently, he failed to qualify as a citizen under Section 3 or under Section 6, capital A within bracket 3 of the Citizenship Act. Stop para. Before proceeding further, the court would like to examine the tribunal records. Stop. The registry will call for the tribunal records pertaining to case number so-and-so from so-and-so tribunal. Para. In the interim, the petitioner will appear before the SP border Borpeta within a period of 10 days from today And if the petitioner is not arrested in the meantime, the petitioner will furnish a bail bond of rupees 5,000 with two local securities of like amount. And in which event the petitioner shall not be arrested or deported out of the country in pursuance to the opinion dated so and so. Stop the SV border, Borpeta will also record the biometrics of the iris of both PIs and fingerprints. And also will record the particulars regarding the residence and the other details of the petitioner for securing his presence wherever required, whenever required. Matter be listed after receipt of the tribunal records after 3 weeks.
Deeply obliged, Lordship.
Item 13.
May please, your lord. Yes, may please, your lordship. My lord, in order of the learned honest tribunal, Kolkata, my lord, is at page number 11, 111, my lord. A relevant portion begins from page number 115, including the summary and opinion, my lord. So basically, my lord, the learned tribunal has declared me a foreigner. The main ground that, my lord, the name of my father appears at two different villages in the same year with different age, my lord. At the same time, look, one of the document which I annexed in my written statement, this is a linkage certificate issued by the Gaon Panchayat, my lord. It has not been referred to by the learned tribunal, my lord. It forms part of my annexure. Look, what has happened is, my lord, in the year 1965, my lord. As to why my father's name appears in two places, my lord, I have an explanation to that, my lord. Which document you said? My lord, that is page number 98, my lord. Of the writ petition, my lord. It's a public document, my lord. Gram Panchayat linkage certificate, my lord. My lord. Because why this is not admissible? My lord, yes. But my lord, apart from this, my lord, what has happened is, my lord, in the year 1965, my lord. My lord will kindly come to page number 29, my lord, of the writ petition.
You are referring to exhibit 9 and 10, which you say is not considered.
No, my lord. In page number, this is one of the enclosures of the written statement, my lord.
No, but was it an exhibit?
Uh,
Page number?
My lord, the Gram Panchayat linkage certificate is at page 98, but my lord, I am actually referring to page number 29, my lord, of the writ petition, my lord.
one and Alexander.
You are in very good hands. None of the documents were exhibited. Come to page 99, that is your evidence. No, not a single document was exhibited.
99.
Now, in your own evidence at page 100, you say I was brought up at Gandhipara. I have obtained residence certificate from Gaonpura of the village Gandhipara and also from the village of Chengalia. And none of these Gaonpuras were examined. A certificate by a Gaonpura must be exhibited by the Gaonpura. You never called them.
The Gaonpura certificate is there and this is a Gaon Panchayat linkage certificate. my lord.
Gaon Panchayat certificate is not a public document.
Madam, initially, my parents in the year 1965 were residents of Jakli Pilar Pathar, my lord. Their names are reflected in, my lord, page number 29, my lord. Abdul Majid Ali and Alexander Nisa, my lord. Then, my lord, in the year 1970, my lord, my father, he
There's an exhibit. Whatever is there is considered. Whatever is produced, even exhibits were there. Considered.
basically, you know, my father's age was recorded wrongly in when he made arrangement to shift his family to Gandharipara, my lord. At that point of time, my lord, he was alone in that new place, my lord. So his age was recorded wrongly and only his name was taken, my lord, in the voter electoral roll. Thereafter, at page number 33, my lord, once he returned back to his initial village of Jakli Bilar Pathar, then, my lord, his age is correctly reflected, my lord. Page number 33. See the third name, Abdul Majid Ali, age 50 years.
Well, we're calling for the records at this stage.
To be, yes, my lord. That record will be necessary, my lord. No, because my name appears here.
Yes, it's heard learned counsel for the parties. The writ petition is directed against the order dated 4/6/2022,
Yes.
passed in BPT 11th FT 1434/2017 by the Foreigners Tribunal Assam for PETA 14th. Stop by the said opinion. The reference preferred by the state was answered in affirmative, and the tribunal opined that the opposite party, the proceeding could not discharge the burden of proving the identity, her identity and nationality, and consequently could not discharge the burden of proving her entry into Assam prior to the cutoff date of 25/3/1971. Stop. At this stage, the court would like to examine the tribunal records. Let the registry call for the tribunal records pertaining to so-and-so case number from so-and-so tribunal. The prayer for interim shall be considered upon receipt of the tribunal records list on 21st of October.
I'm highly obliged, my lord.
Mr. Khan, your matter will be taken up day after tomorrow. No other prayers for listing on Thursday can be considered, but Mr. Khan's matter will take it up. Mr. Khan, you also give a short synopsis of your submissions.
My lord, motion matter, my lord, left over.
Those will be listed. The court master will take care of those motion
Item
matters.
15, my lord, the petitioner
Alright.
is in detention center, my lord. Good. Item 15, my lord. Petitioner is.
This is a motion matter.
Yes, my lord.
They will come. Motion matters will,
As per the
motion matters will come.
day after tomorrow, my lord.
No, it will come
It will come.
within day after and the day after day after. Both these matters will come.
Lord, I have a prayer, my lord, in respect of item 26, my lord. There is an interim order. Let me continue, my lord. 26.
It's from the court master.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 4 and 5. My senior colleague as when he is out of station, lordship.
4 and 5.
Yes, lordship.
Okay, both sides are there.
My lord, kindly fix the matter on third, my lord. There is some urgency actually.
Third is not possible. We're not having a
And my
single
lord,
bench.
on fourth,
It goes after vacation.
yes, my lord, there are some urgency actually.
We can't help it. Because just before vacation, we can't have a single bench. Both sides are represented on the prayer made on behalf of UFO.
Petitioner. Lordship, in item number 4, I am respondent, and item number 5, I am repeat.
In item 3, you are,
Three,
item 4, item 4,
I am respondent.
okay. For the respondent in the interlocutory application and the petitioner in the review petition. The matter stands adjourned today. List the matter immediately after the ensuing Puja vacation. Next para, the learned counsel for the Register of Cooperative Societies expresses some urgency in the matter. So accordingly, leave is granted to move the registry if the matter is not listed immediately after the vacation.
May it please your lordship. Lordship, with due consent of the other side, lordship, I beg to mention item number 2. In this case,
Item?
item number 2, lordship. In this case, I have been instructed not to press this application, so I may be allowed to withdraw this.
Okay. Both sides are represented. Upon instructions, Ms. T. Som, counsel for the petitioner, submits that she has instructions not to press the matter. So accordingly, this bail application stands closed as not pressed.
Applies.
Item 1, motion BA.
May it please your lordship. My lord, this is a bail application. My lord, the only point which I'll be urging is that, my lord, the petitioner was arrested on 19/12/22. So now the petitioner is in custody for more than 625 days.
Okay, we issue notice.
My lord, at this stage, the prayer which I'm making, perhaps, my lord, it's covered by, if lordship may kindly consider.
I know.
My lord, in case where, my lord, the
That's it.
trial is likely to be delayed, my lord, the fetter of section 37 will not come. My lord, in a case where the order I'm referring, in this case, my lord, it was 1 year and 6 months, where bail was granted on the ground of, my lord, incarceration, in which case it will be violative of Article 21. Now, if Lordships would kindly come to para 2, Milord, relying on the Supreme Court judgment. This application under section 439 of the Code of Criminal Procedure has been.
So it's
filed by the
okay,
petitioner.
because this is a bail application, I have to issue a notice to them.
Of course.
Uh, The,
Milord,
the previous.
will it be too
where
much
is the
if I
previous
ask for
order?
fourth, Milord?
Both I don't think there'll be a single bench.
Because, my lord, the nature of prayer I am making, perhaps, my lord, CD may not be necessary also. Of
No, we are
course,
not asking for the case
yes,
diary.
of course, notice
We'll
has to
call
be
for the
issued.
previous, in the previous order,
Yes,
the scanned copies are available.
yes.
Normally, if
No, my lord, the position is there are 12 witnesses. Only 3 witnesses has been examined by the prosecution witnesses.
Okay.
In the case which I am referring to, there 9 witnesses were there, out of which only 2 were examined. And he was in custody for 1 year, 6 months. Here it is, my lord, 625 days. It's almost 2 years.
because you see that the second part of your submission, that fetters of 37 would not be there. There is again a reported decision by a 3-judge bench. 37 is available. It's applicable. Narcotics Control Bureau.
In fact, my lord, I am relying on a 3-judge bench only. 2022 SCC 1925.
20.
2022.
What is the name?
My lord, party's name is Sariful Islam versus State of West Bengal.
Oh,
That
no.
is by Honorable Chief Justice Krishna Murari and Hima Kohli. It has been referred in this case, my lord, at para 8 of the coordinate bench order. Learned counsel for the
You
petitioner
see
has
this,
relied on a
this
full.
Shariful,
Yes,
I have dealt with in the earlier order, page para 22. You see that? In the earlier order of the court,
okay, my lord.
please check it up. Because you may have to reformulate your para 22 of the previous order.
Hmm. No, my lord, only fact that was considered in Sariful was the delay, the trial was likely to be delayed. That is why it was said, my lord, fetters of 37 will not apply. Hmm?
Yeah.
And moreover, my lord, nothing was recovered from us also. And that is on the merits, of course.
Because the previous order,
Yes.
if
No,
you-
Lordship has dealt with it. I have seen the order, my lord.
because in para 26 again,
Yes.
I have referred to another 3-judge bench.
Hmm. I have seen it, my lord, that Hira Singh.
You are saying.
Hmm.
Because even we have referred to various 2-judge benches decision of the Supreme Court of India,
Hmm.
where we found a very strange thing caught the eye. Because the earlier orders of the Supreme Court were never referred to. There's a direction even in one of my orders where the Supreme Court has interfered and granted bail. But incidentally, none of these decisions of 3-judge bench, there are 3 or 4 judgments of 3-judge bench of the Supreme Court, which has never been touched or explained in the cases where bails are granted. That is why perhaps you'll also
Anyway, my lord,
have to.
I'll address on those issues.
Achha. Acha, in the last order also, there was a single bench matter. Since this is a bail matter, we are fixing a date. In the earlier first case also, give a date, same date of single bench. But Mr. K. N. Chaudhary, Lanet Senior Counsel, assisted by Mr. P. Som, Learned Counsel for the petitioner. Next, the Learned Counsel for the Learned Senior Counsel has submitted that as the previous application for bail was rejected by this bench, comma, this matter is tagged with this bench. Full stop. He also has submitted that till date only 3 witnesses have been examined and there is no likelihood of an early trial, and therefore this is the prayer for bail. Next paragraph. Mr.
A. Jain.
A. Jain, you appear for Mr. Kyal. Mr. A. Jain, Learned Counsel, appears on behalf of Mr. S. C. Kyal, Learned Standing Counsel for the NCB. Next paragraph. If you notice, returnable on, give fixed date. On 24/10/2024. Next paragraph, let the records of BA number 4258 of 2023 be tagged along with this bail application. Is this scan copy available in the earlier record? Have you checked this order? The
225.
So next paragraph, the next paragraph. As the prayer for bail is made on account of long detention and only on the ground that only 3 witnesses were examined, comma, there is no necessity to call for the scan copy of the records. Next paragraph. Therefore, the registry shall this evidence of PW3, is it available, Mr. Chaudhary, here?
Not will, if necessary, we'll bring on record by an affidavit.
Okay. As the Learned Senior Counsel for the petition has submitted that the evidence of PW2 and any other witnesses that may be recorded in the meanwhile shall be brought on record by way of an affidavit.
On the reopening day itself, we'll do that.
Next page. You want to produce anything?
I'll file my status report. Lords.
Oh, okay. The next paragraph on the prayer made by the Learned Counsel for the NCB is permitted to file a status report of trial. In the matter, next paragraph, list on 24/10/2024.
Deep reply.
Mr. Chaudhary, can I
Yes,
give it back
yes.
to you? Can I give it back to you?
No, my lord, lordship can be retained in the file. We'll have the copy.
Item 3 for orders.
With you, Lordship. So in this case, one petition had been filed, bail application. As per the amended provision of the Guwahati High Court rules, at page 11, the petitioner has to give his mobile phone number. It doesn't specify, my lord, exactly whose mobile number, but it is said, my lord, mobile number, my lord, contact number, and if during pendency of the instant
I
proceeding,
don't
there
get
is
it.
change
Please,
in my
please,
contact number.
please
I
say again.
undertake. Page 11, my lord.
Yes.
The mobile number in which I can be contacted is so and so, and if during the pendency of the instant proceeding there is a change in my contact number, I undertake to inform the registry of this honorable court. But pursuant to this amendment, my lord, in the affidavit, your lordship will find in the instant affidavit as well at page 8. Paragraph 3. That the mobile number in which I can be contacted is so and so. Here two numbers have been given. Now, my lord, the first one is belong to his father. The second was the advocate who was engaged by him in the trial court, and is a, my lord, family friends also.
We
So
take an
their number
exception
has
to
been
that.
given.
We took an exception to that. The reason being that
Lordship. Now, my lord, will find the format that is given, my lord, at page 12. My lord. And come to
Yes.
page 13. My lord.
you see in page 13, there is a second alternative. I do not have a mobile. So therefore, if he does not have a mobile, then he gives the number of his
He
advocate.
doesn't have a mobile, my lord. So therefore, he doesn't have a mobile. So he has given the number of the advocate, who is also a family friend, my lord. Vasant
No,
Na.
but this is not the statement in the affidavit.
My lord, this form was filled up, my lord.
No, look at the
This-
affidavit. It is there. The affidavit is here. It will be.
Perhaps the same format that you. Well, I have the copy. This statement came pursuant to, my lord, this amendment, my lord, page 11.
We understand that.
It is with me, my
Oh,
lord,
it
the
is
copy
there.
of the earlier.
You see, because he does not say that I do not have a phone
This is
number.
also, my lord, goes to the, my lord, council, my lord, he also thought, my lord, any advocate number will do so, my lord, the council has signed it, my lord, that is the thing, otherwise the
This
mobile
actually
number
we
is
have to-
of
we
an
have to
advocate.
stop it. You see, the reason is that it's not only a singular case, but there are a lot of cases piling up where after the adverse orders are passed or cases are dismissed for default, then
Yes.
then the applicants come and say that my advocate did not contact me.
Right.
I did not have information. I did not take steps.
Right.
So it is in order to curtail those. And second is that if those numbers are updated in our system, at least we can give them a SMS whenever required. The communication can be there. But if
Madam, the bar council
statement is
also,
made.
my lord, we have been, my lord, received various complaints, my lord, after dismissal of the, my lord, this dismiss for default, etc. My lord, we received, my lord, he was also the chairman of the bar council, my lord, senior council. He will be also aware. Most of the complaint that the advocate did not inform us this, that, and all, my lord. Half of the complaints are like this, my lord. That, my lord, goes, my lord, as a procedure. But here, my lord, so far as, my lord, this, my lord, the you will find page 11. But it was, my lord, the page 11, my lord, is a single line to be incorporated, my lord, the mobile number in which I can be contacted. So he has given a mobile number. And if during the pendency of the instant proceeding, there is a change in my contact number, I undertake to inform the registry of this court. So this has been incorporated in the affidavit.
And he is an advocate, my lord, and who is a family friend also near is staying there. Any my lord, message goes to him, my lord, he can deliver it, my lord, rather than the advocate who is present in Guwahati, my lord. So therefore, that number had been given, my lord. Not only confusion, my lord, we will find, my lord, the format that has been prescribed is 13. At least, my lord, this word, my lord, false statement, if it, my lord, can be, my lord, expanded. My lord, so it's not a, my lord, false, my lord, wrong understanding or wrong interpretation or, my lord, wrong understanding. But then, my lord, this, as your lordship has seen, the amended clause has been incorporated in the affidavit. There is another issue, my lord, your lordship will, my lord, recollect, my lord, in the annexures, the advocate has to certify, my lord. And most of the cases in my lord, practice, my lord, these photocopies are given to the councils. It is not the original government records cannot be, my lord, photocopies are given. And the advocate believing the, my lord, the client, my lord, certified that the certified to be true copy of the original, but the council do not see that, my lord. Many a times, my lord, it happens that the document is fabricated, which was given by the client himself, my lord. Just to that extent, my lord, the false statement, my lord, the observation, my lord. So this false statement will have a many implication under the IPC, making a false statement in court, etc. Which is a document. Proceeding can also be initiated.
Yes, Mr. Sharma.
But this is, my lord, as referred by my lord, page 11, my lord. It, I can be a mobile number in which I can be contacted. Perhaps that was the impression of the council.
Okay, I will check with the registry and then I'll pass appropriate orders. If for some reason I can't pass an order today, it will be listed again in the motion. Sorry, in the orders column. Orders column.
Belongs to that advocate, to that effect, no problem. He is this Basant or not? He is also a practicing advocate at Lakhimpur, whose number was given there.
I'll just I'll just take a stock of situation from the registry and then I'll pass orders. If for some reason I can't pass an order today, it will be listed again in the orders.
Oblige.
P. Sharma, Mr. Seke along with Mr.
Yes. Rahman Lordship.
M. Rahman. Just note their names. Okay.
My lord, now after that, my lord, we are now strictly instructed our clients to give their number. After that.
You see, we are trying to
Yes.
have a system where the reason to have numbers is not for anything else, but to ensure that there's no matters which are dismissed for default.
Yes.
So sometimes advocates given the number because they have no number. That reason I was going to stop it. We are, I expect
I'm not
every
making
client
any
to
comment.
give the number.
I'm not making a comment on anything. But the system is being created so that
Yes.
we have a database.
At least the message should go up, my lord. Many times it happens that council also do not inform the clients and he suffers. My lord.
No, but you
Sometimes.
see, we are spending a lot of money in giving SMS messages to have our system upgraded. I believe some of you must be receiving the SMS.
Assamese, my lord, I haven't received as yet. Assamese, I haven't received as yet, but the filing number, those all comes in English.
Message.
Message we are receiving with regard to filing and
In every
the
case,
listing
we
also,
receive
next day.
listing also you should be getting.
In-
No, you as a senior counsel will not get, but listing,
Now we are receiving the message.
Oh, yes, my lord, these are being sent.
listings are being issued. And we are spending a lot of money in payment of SMS charges. So we want to have a foolproof system where at least the client comes to know that the matters are there. The live streaming is going on. The purpose is only that the clients can, the litigants are aware of it. You see, who on the earth would be interested in this interlocutory application and some people will be listening to it, watching the video of today's proceeding. Nobody is interested in any matter which is listed today, it is in this single bench. Nobody in the world would be interested except the litigants.
Exactly.
Nobody would be interested in this, your application. Nobody would be interested. Nobody would spend time watching this video of today's proceeding only for this reason. So the idea is that the petitioners are, the parties are updated. Only that is the reason. But I'll check with the registry, see what has happened and then.
Oblige.
Item 6 for hearing.
Yes.
M. Roman.
Lordship.
Yes, Mr. Naik.
Lordship, we filed this election petition on 4 grounds, Lordship. That is one.
Yes.
Lordship, 4 grounds, Lordship. That is one, non-disclosure of 3 affairs which were pending against the respondent, Lordship. And that was not disclosed in the affidavit, election affidavit filed by the respondent, Lordship. Respondent number 1.
Yes.
Secondly, Lordship, non-disclosure of immovable or movable assets, Lordship, not fully disclosing, Lordship, not fully disclosing the movable and immovable asset in clause 7A of the said affidavit, Lordship, form 26 affidavit.
Yes.
Thirdly, Lordship, on the ground of non-disclosure of the contracts that the private respondent entered into,
Yes.
and that is clause 9B of the said affidavit, Lordship. In fact, this was a contract he entered into with HPC, and a pending bill was there for an amount of rupees 7,99,34,327.
Yes.
And fourthly, Lordship, improper acceptance of nomination paper.
Improper.
Acceptance of nomination paper.
Yes.
And prayers were made, Lordship, accordingly. Prayer number 1, to declare the election of the respondent number 1 as void and be struck down.
Yes.
And grounds we took, Lordship, section 98B, section 101B,
98B.
B, Lordship, AB, small b, 101B, 101D, Roman 1, small 1, Lordship, 101D1, and 101D4.
Thank you.
Yes.
But an application was filed by the petition respondent under order 7, rule 11, Lordship, for rejection of the election petition, Lordship. Lordship, if I may come to the order 7, rule 11, Lordship, that is rejection of claim, Lordship, can we see the grounds, Lordship, there? Order 7, rule 11, Lordship, 4 grounds are there
Yes.
where it does not disclose a cause of action
where the relief claim is undervalued and the plaintiff, on being required by the court to correct the valuation within a time to be fixed by the court, fails to do so. 3. Where the relief claim is properly valued, but the plaintiff is returned upon paper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within a time to be fixed by the court, fails to do so. And fourth, Lordship, where the suit appears from the statement in the plain to be barred by any law. In the application filed by the petitioner, if Lordship comes to paragraph 9, Lordship, paragraph 9 of that application, Lordship, Order 7 Rule 11 application.
Order 7 to 11.
Yes, filed by the respondent, Lordship. Application filed by the applicant, paragraph 9.
Yes.
Here, Lordship, the applicant took 2 grounds, Lordship. That upon receipt of a copy of the election petition, the respondent applicant has carefully perused contents of the same. On a combined reading of the pleadings made by the election petition, the humble applicant finds that the election petition is liable to be rejected under Order 7 Rule 11 of the Code of Civil Procedure 1908. Firstly, for non-disclosure of essential material facts giving rise to a cause of action with any triable issues, and secondly, the election petition as it appears from the pleadings made therein is barred under different provisions of the Representation of the People's Act, read with the conducts of the Election Rules 1961 framed under the Act. So these are the grounds taken by the applicant, Lordship, not other grounds. So far as the first ground is concerned, Lordship, I will make submission. But so far as the second ground is concerned, this application is completely silent as to which particular provision bars me filing this election petition. Only the Lordship, in response to the application filed by the petitioner, we filed one objection, Lordship. Lordship, I would like to go through 2-3 paragraphs of that objection, Lordship. Lordship comes to paragraph 1. Lordship, in paragraph one preliminary issue was raised as regard whether an application can be filed without the permission of this court or not. Lordship has already decided that issue, but therefore we are not going to that particular issue. Coming to paragraph number 2, Lordship.
Yes.
That it is being submitted that under Order 7 Rule 11 of the Code of Civil Procedure 19A, the plaint shall be rejected in the following cases: where it does not disclose a cause of action, where the relief claim is undervalued, and the plaintiff, on being required by the court to correct the valuation, when a time to be fixed by the court fails to do so. See, where the relief claim is properly valued, but the plaint is written upon papers insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within a time to be fixed by the court, fails to do so, and D, where the suit appears from the statement in the plaint to be barred by any law, provided that the time fixed by the court for the correction of the valuation or supplying of the requisite stamp paper shall not be extended unless the court, for reasons to be recorded, is satisfied that the plaintiff was prevented by any cause or an exceptional nature from correcting the valuation of supplying the requisite stamp papers, as the case may be, within the time fixed by the court, and that refusal to extend such time would cause grave injustice to the plaintiff. On detailed reading of the instant application, it appears that the instant application filed by the respondent on 2 grounds. Firstly, for non-disclosure of essential material facts, giving rise to cause of action with tribal issues. And secondly, the election petition is barred under different provisions of the Representation of the People's Act 1950, read with the Conduct of Election Rules 1961, which the election petitioner, opposite party herein, chooses to deny. Firstly, on the ground that it is well settled that the election petition will have to be read as a whole and cannot be dissected sentence-wise or paragraph-wise to rule that the same does not disclose a cause of action. Cause of action embodies a bundle of facts which may be necessary for the plaintiffs to prove in order to get a relief from the court. Under the provisions of law, the requirement is a concise statement of the material facts or which the petitioner relies. The election petitioner, opposite party, in her election petition plainly disclose the facts which are material facts for adjudicating the grounds for declaring the election of the respondent applicant as being void because of non-disclosure of full criminal antecedents by the returned candidate. In the affidavit form 26, non-disclosure of full details of the assets, vehicles owned by the returned candidate and his spouse as to the year of purchase of vehicles and the amount at which the vehicles were purchased by the returned candidate in the affidavit form 26 by mentioning an amount as value of the vehicles, which is much below the current market value, non-disclosure of details regarding any investment on the land by way of development, construction, etc. In clause 7B, details of removable assets at serial number 2 non-agricultural land in the affidavit form 26, making false statement in clause 9B, serial number A to F of the affidavit as regard details of contract entered into by the candidate or his spouse or by a partnership firms and private company in which the candidate or spouse or partner of shareholder and improper acceptance of nomination paper of the returned candidate by the returning officer. As stated above, cause of action embodies a bundle of facts which may be necessary for the plaintiff to prove in order to get a relief from the court. The reliefs claimed by the election petitioner are founded on the grounds ascribable to section 101B, section 101D1, section 101D4, and the Representation of the People Act 1951. These are all cause of action for filing the election petition. For example, one of the cause of action for filing of the election petition therefore was perceptibly in reference to the material facts depicting that nomination form of the respondent return candidate was improperly accepted by the returning officer. On the second allegation that the election petition is barred under different provisions of the Representations of the People Act 1950, read with the Conduct of Election Rules 1961, which the respondent applicant explained at paragraph 4 of the application, is also categorically denied and liable to be rejected, as the applicant has failed to specify which of the requirement under section 83 of the Representation of the People Act 1951 read with the requirement of Order 6 Rule 2, Order 6 Rule 4, and Order 6 Rule 1 of the Code of Civil Procedure 1908 has been complied with, has not been complied with. 3. That it is being submitted that the dismissal of the election petition under section 86 of the Representation of the People Act 1951 as freed by the respondent applicant is possible only in cases of non-compliance of the provisions of section 81 or section 82 or section 117 of the Representation of the People Act 1951. As is apparent from the perusal of the instant application, the applicant nowhere alleges any violation of the provisions of section 81 or section 82 or section 117. Moreover, an order of the High Court dismissing an election petition under section 86(1) shall be deemed to be an order made under clause A of section 98 of the Act, meaning thereby that dismissal of an election petition under section 86 is possible only at the conclusion of the trial of an election petition. Accordingly, prayer made by the respondent applicant for disposal of the election petition under section 86 of the Representation of the People Act 1951 before conclusion of the trial is not maintainable. Four, that as regards to the averments made in the instant application filed by the respondent applicant under Order 7 Rule 11 of the Code of Civil Procedure 1908, the election petitioner opposite party herein begs to state that it is the settled principle of law that the power conferred on the court to terminate a civil action is a drastic one, and the conditions enumerated under Order 7 Rule 11 of the Code of Civil Procedure 1908 are required to be strictly adhered to. Under Order 7 Rule 11 of the Code of Civil Procedure 1908, the duty is cast upon the court to determine whether the plaintiff discloses a cause of action by scrutinizing the averments in the plaint, read in conjunction with the documents relied upon, or whether the suit is barred by any law. It is further settled that under Order 7 Rule 11 of the Code of Civil Procedure, only the pleadings of the plaintiff are looked into, neither the written statement nor the averments and contentions or the case pleaded by the defendants can be considered for an inquiry under the said order. Accordingly, it is submitted that this honorable court, while considering the application filed under Order 7 Rule 11 of the Code of Civil Procedure 1908 by the respondent applicant, alleging non-disclosure of cause of action in the election petition, will only read the averments in the election petition, not formally, but also meaningfully, and decide the same exercising the power under Order 7 Rule 11 of the Code of Civil Procedures. 5. In view of the above explained facts and settled legal position, now the election petitioner opposite party wherein begs to reply to the statements and averments made by the respondent applicant in the instant application as follows. Dear Lordship, I would like to rely upon all the paragraphs, Lordship, that I have 5.1, Lordship, that the contents of paragraph numbers 1 and 2 of the election application, and I'm not going through. 2, Lordship, 5.2, page 8, Lordship. That as regards to the statements made in paragraph number 3 and 4 of the instant application, the election petitioner opposite party herein begs to deny the same to the extent that the said paragraphs do not constitute material facts of about corrupt practice and undue influence to give rise to a cause of action. The election petitioner opposite party further relying upon the statements made in paragraph numbers 1, 2, and 3 of this reply and reiterating the statements made in paragraph number 20 of the election petition begs to submit that the contentions of the respondent opposite party are liable to be rejected. And 5, Lordship, 2.5, page 9. As regards to the statement made in paragraph number 7 of the instant application, the election petitioner opposite party herein begs to deny the contention of the respondent applicant and further begs to state that as stated earlier, it is well settled that the election petition will have to be read as a whole and cannot be dissected sentence-wise or paragraph-wise to rule that the same does not disclose a cause of action. Accordingly, the election petitioner opposite party begs to submit that the contentions of the respondent opposite party are liable to be rejected. Next paragraph, Lordship, paragraph 8, reply to paragraph 8. As regards to the statements made in paragraph number 8 of the instant application, the election petitioner opposite party herein begs to deny the same to the extent that no material facts and supporting particulars have been disclosed to show how, who, and in what manner the voters were misled as a result of such improper acceptance of nomination. In this regard, the election petitioner opposite parties herein submits that no question of proving that the election has been materially affected arises, as the returned candidate would not have been able to contest the election if his nomination was not accepted. In such view of the matter, the contention of the respondent applicant is liable to be rejected. Then Lordship 9, page 11, paragraph Roman 9.
Yes.
That as regards to the statements made in paragraph number 16 of the instant application, the election petitioner opposite party herein begs to deny the same and further begs to state that while filing nomination form, if the requisite information as regards criminal antecedents, details of assets, etc., undoubtedly, etc., there is an attempt to suppress, effort to misguide and keep the people in dark. Such an attempt, undeniably and indisputably, is undue influence and therefore amounts to corrupt practice. Then, that as regards to the statements made in paragraph number 17 and 18 of the instant application, the election petitioner opposite party herein begs to deny the contention of the respondent applicant that unverified statements and submissions cannot give rise to cause of action and will not constitute material facts. The election petitioner opposite party further begs to state that the omission or defects, if any, in the election petition are curable in irregularities only. However, it is categorically stated herein that there is no omission or defects in the instant election petition. 11. As regards to the statements made in paragraph number 19 and 28 of the application, the election petitioner opposite party herein begs to submit that as these are basically submissions on merit, at the stage of consideration of an application under Order 7 Rule 11, such statements are not relevant for consideration and accordingly liable to be rejected. It is further stated that disclosure of criminal antecedents is a requirement of Form 26, and apparently by not disclosing the pending affairs against him, the returned candidate resorted to suppression which amounts to undue influence as provided in section 123 of the Representation of the People's Act 1951. That is to say, any direct or indirect interference or attempt to interfere on the part of the candidate with the free exercise of any electoral right. 12. That as regards to the statements made in paragraph number 29 and 30 of the application, the election petitioner opposite party hearing begs to deny the same in general, and in particular the statement that in the absence of material facts, there cannot be any cause of action with tribal issues on improper acceptance of nomination. In this regard, the election petitioner opposite party herein submits that no question of probing that the election has been materially affected arises as the returned candidate would not have been able to contest the election if his nomination was not accepted. In such view of the matter, the contention of the respondent application is liable to be rejected. Further, paragraphs 24 and 25 of the election petition are to be read conjointly with paragraph 20, 21 and 21A of the petition. Moreover, omission or defects, if any, in the election petition are curable ingredients or irregularities only. However, it is categorically stated herein that there is no omission or defects in the instant election petition. 13. That as regards to the statements made in paragraph number 31 and 32 of the application, election petitioner opposite party herein begs to deny the same as not relevant, as these are submissions on merit and accordingly liable to be rejected. However, from the statements made in these two paragraphs of the application, the election petition opposite party would like to highlight that the respondent applicant has admitted that the voter information available in the website of the Election Commission of the India. Election Commission India shows that the name of the respondent applicant is recorded as Nizamuddin Chaudhary. What Z is concerned, spelling is concerned, Lordship, I'm on that, Lordship. Accordingly, Lordship, we objected to the prayer, Lordship. The election petitioner opposite party praised before this honorable court that in accordance with the facts and circumstances of the case mentioned above, the election petition and the present reply, that this honorable court may be pleased to dismiss the present application for rejection of the dismissal of the election petition with exemplary cause. Basically, Lordship, these are the facts, Lordship. So at this stage, Lordship, I would like to rely upon 2-3 judgments, Lordship. And the first one is 2005 13 SCC 687.
Two thousand?
2005 13 SCC 687. Lordship, these are judgment basically that settles the law as to when an application under Order 7 Rule 11 is adjudicated, Lordship. What are the issues this honorable court will look into, Lordship? One small paragraph, Lordship, very small judgment. Paragraph 3. Paragraph 3.
Just a moment. Yes.
Paragraph 3, we find that the directions for considering the question relating to Order 7 Rule 11 CPC as preliminary issue is not correct, as that would necessitate filing of a written statement. It is a settled position in law that while dealing with an application under Order 7 Rule 11 CPC, considering of written statement is not a condition precedent and only averments in the plain have to be considered. Therefore, that part of the order is set aside. It will be in the interest of the parties if the whole suit is taken up for disposal as early as practicable, considering the fact that the suit was filed in 1976. Learned Counsel for the parties submit that they shall cooperate with the disposal of the suit. This part I am not concerned, Lordship. Only one that line, Lordship. Only averments made in the plain have to be considered. That is one, Lordship. On the same issue, Lordship, another judgment I would like to place now. 2021 9 SCC 99. 2021 9 SCC 99. Paragraph 17.
Yes.
2021 9 SCC 99, paragraph 17. May I read, Lord?
Yes.
17. Order 7 Rule 11D CPC provides that the plain shall be rejected where the suit appears from the statement in the plain to be barred by any law. Hence, in order to decide whether the suit is barred by any law, it is the statement in the plaint which will have to be considered. The court, while deciding such an application, must have due regard only to the statements in the plaint. Whether the suit is barred by any law must be determined from the statements in the plaint, and it is not open to decide the issue on the basis of any other material, including the written statement in the case. এটা কোনটো কোন 28 page এইখানটা না 8 9 10 next judgment, Lordship, I am relying upon is 2027 SCC 366. 2027 SCC 366.
368.
3666, Lordship.
Okay.
366.
Yes.
Paragraph 23.1, page 376.
Yes.
23.1, we will first briefly touch upon the law applicable for deciding an application under Order 7 Rule 11 CPC, which reads as under. Also, I am coming to paragraph 23.8, page 378. Three seven eight 23.8. Having regard to Order 7 Rule 14 CPC, the documents filed along with the plaint are required to be taken into consideration for deciding the application under Order 7 Rule 11A. When a document referred to in the plaint forms the basis of the plaint, it should be treated as a part of the plaint. 23.10. At this stage, the plea taken by the defendant in the written statement and application for rejection of the plaint on the merit would be irrelevant and cannot be adverted to or taken into consideration. 23.11, the test for exercising the power under Order 7 Rule 11 is that if the averments made in the plaint are taken in entirety, in conjunction with the documents relied upon, would be same result in a decree being passed. This test was laid down in Liverpool versus London SP, so and so, which read as 139. Whether a plaint discloses a cause of action or not is essentially a question of fact, but whether it does or does not must be found out from reading of the plaint itself. For the said purpose, the averments made in the plaint in their entirety must be held to be correct. Then Lordship 23.12, in Hardes Ores Private Limited versus Head and Company, the court further held that it is not permissible to call out a sentence or a passage and to read it in isolation. It is the substance and not merely the form which has to be looked into. The plaint has to be construed as it stands without addition or subtraction or of words. If the allegations in the plaint prima facie show a cause of action, the court cannot embark upon an inquiry whether the allegations are true in fact. But these three judgments are also I'm relying upon basically to submit that at this stage, while your Lordship is adjudicating this application file under Order 7 Rule 11, Lordship will not take into consideration the pleadings made in the application itself or any submission made by the counsel appearing for the applicant Lordship. Lordship will only go through the pleadings in a plaint and decide whether it discloses any cause of action or not. Lordship, as I have mentioned earlier, Lordship, in the application, petitioner has only two grounds: non-disclosure of cause of action and barred by any law. That second ground is concerned, no pleadings are there, Lordship. No, not a single averment is there, or which particular provision has been violated, or by which particular provision this petition is barred that has been filed by the election petitioner. So coming to the cause of action, Lordship, at that point, for that also, Lordship, I would like to rely some judgment, Lordship, to look into what is the cause of action, Lordship. Two 2012 8 SCC 706.
2008.
2012 8 SCC 706.
What's the name of the parties?
This is source of Christ Charitable Trust and Educational Charitable Society, Lordship. Onyaman Education Trust. Source of Christ.
Yes.
Lordship, I'm at paragraph 13, Lordship, page 715. Paragraph 13, cause of action.
$38.
13, Lordship, 13,
1,
13. Cause of action. While scrutinizing the plain averments, it is the bounden duty of the trial court to ascertain the materials for cause of action. The cause of action is a bundle of facts which, taken with the law applicable to them, gives the plaintiff the right to relief against the defendant. Every fact which is necessary for the plaintiff to prove to enable him to get a decree should be set out in clear terms. It is worthwhile to find out the meaning of the words cause of action. A cause of action must include some act done by the defendant, since in the absence of such an act, no cause of action can possibly accrue. 14. In ABC Lemonade Private Limited versus AP Agencies, this court explained the meaning of cause of action as follows. Well, a cause of action means every fact which if traversed, it would be necessary for the plaintiff to prove in order to support his right to a judgment of the court. In other words, it is a bundle of facts which, taken with the law applicable to them, gives the plaintiff a right to relief against the defendant. It must include some act done by the defendant, since in the absence of such an act, no cause of action can possibly accrue. It is not limited to the actual infringement of the right sued on, but includes all the material facts on which it is founded. It does not comprise evidence necessary to prove such facts, but every fact necessary for the plaintiff to prove to enable him to obtain a decree. Everything which, if not proved, would give the defendant a right to immediate judgment must be part of the cause of action, but it has no relation whatever to the defense which may be set up by the defendant, nor does it depend upon the character the relief prayed for by the plaintiff. 15. It is useful to refer the judgment in Bloom Decker Limited versus Subhas Himatlal Desai, wherein a three-judge bench of this court held as under 28. By cause of action, it is meant every fact which, if traversed, it would be necessary for the plaintiff to prove in order to support his right to a judgment of the court. In other words, a bundle of facts which it is necessary for the plaintiff to prove in order to succeed in the suit. It is mandatory that in order to get relief, the plaintiff has to aver all material facts. In other words, it is necessary for the plaintiff to aver and prove in order to succeed in the suit. Next video. Paragraph 13, 14, and 15. document of our liquidators defective paragraph 9. Yes. 2012 7 SCC 788. Two 2012 7 SCC 788. Similar method. Next, please.
Paragraphs.
Paragraph 3, Lordship, page 793. Paragraph 3, page 793. Having carefully gone through the amendments made in the election petition, we are of the opinion that the election petition sets out the requisite material facts that discloses a cause of action and gives rise to a triable issues, which cannot be given a short shrift by taking an unduly technical view as to the nature of the pleadings. There is no denying of the fact that the courts are competent to dismiss petitions not only on the ground that the same do not comply with the provisions of section 81, 82, and 117 of the Representation of the People Act 1951, but also on the ground that the same do not disclose any cause of action. The expression cause of action has not been defined either in the Civil Procedure Code or elsewhere, and in more easily understood than precisely defined. This court has in Om Prakash Srivastava and Union of India attempted an explanation of the expression in the following words. Well, the expression cause of action has acquired a judicially settled meaning. In the restricted sense, cause of action means the circumstances forming the infraction of the right or the immediate occasion for the reaction. In the wider sense, it means the necessary conditions for the maintenance of the suit, including not only the infraction of the right, but also the infraction coupled with the right itself. Compendiously, as noted above, the expression means every fact which it would be necessary for the plaintiff to prove, if traversed, in order to support his right to the judgment of the court. Every fact which is necessary to be proved, as distinguished from every piece of evidence which is necessary to prove each fact, comprises in cause of action. 5. It is equally well settled that while examining whether a plaint or an election petition discloses a cause of action, the court has a full and comprehensive view of the pleading. The averments made in the plaint or petition petition cannot be read out of context or in isolation. They must be taken in totality for a true and proper understanding of the case set up by the plaintiff. Next, Lordship, coming to paragraph 7, reference may also be made to the decision of this court in Source of Northeast India. This case I have read, Lordship, wherein this court reiterated that for purposes of determining whether the plaint discloses a cause of action, the court must take into consideration of the plaint as a whole. It is only if even after the plaint is read as a whole, no cause of action is found discernible, that the court can exercise the power under Order 7, Rule 11 CPC. Paragraph number 2, apa lagi ni? Itu cause of action apa ni? Then Lordship, one more judgment Lordship I'd like to refer, 2018 14 SCC 1. 2018 14 SCC 1.
Yes.
Paragraph 23 and 24, Lord. The central issue in this appeal is whether the contents of the subject election petition disclose cause of action, warranting a trial. The High Court, by a composite judgment, allowed the two applications filed by the respondent number 1, return candidate, praying for striking out paras 2 and 9 to 11 of the election petition, being frivolous and vexatious and not containing any material facts and not disclosing any cause of action. And the second application for rejecting the application petition in limine for non-disclosure of cause of action. 24. Ordinarily, an application for rejection of election petition in limine, purportedly under Order 7, Rule 11, for non-disclosure of cause of action, ought to proceed at the threshold, or it has to be considered only on the basis of institutional defects in the election petition in reference to the grounds specified in clauses A to F of Rule 11. Indeed, non-disclosure of cause of action is covered by Clause A therein. Consideredly, Order 7 CPC generally deals with the institution of a plaint. It delineates the requirements regarding the particulars to be contained in the plaint. Relief to be specifically stated, for relief to be founded on separate grounds, procedure on admitting plaint, and includes return of plaint. The rejection of plaint follows the procedure on admitting plaint or even before admitting the same. If the court on presentation of the plaint is of the view that the same does not fulfill the statutory and institutional requirements referred to in Clause A to F of Rule 11, the power bestowed in the court in terms of Court Rule 11 may also be exercised by the court on the formal application moved by the defendant after being served with the summons to appear before the court. Be that as it may, application under Order 7 Rule 11 deserves consideration at the threshold. On the other hand, the application for striking out pleadings, that we are not concerned, Lordship, 26. Indeed, the defendants move two separate applications at the same time. As in this case, it would be open for the court in a given case to consider both the applications together or independent of each other. If the court decides to hear the application under Order 7 Rule 11 in the first instance, the court would be obliged to consider the plaint as filed as a whole. But if the court, anyway, Lordship, I'm not relying upon this judgment, Lordship. It was basically this judgment was taken to describe what is material fact and material particulars, Lordship. For that, Lordship, we will come again to this judgment, Lordship. Paragraph 19 is relevant. Paragraph 8 is relevant. I'll come to this judgment, Lordship. Now, Lordship, after this, Lordship, I would like to place the petition, Lordship, election petition.
Mr. Nayak, here the paragraphs where this 1814 SCC page 1, what are the paragraphs here?
1814. Last judgment, Lordship.
Yes.
Paragraphs that I read, Lordship.
Huh.
It's for 23 and 24 I Lordship, but I thought these are not necessary, Lordship, at this stage.
Okay.
I'm basically relying upon another paragraph, Lordship, that I will place at a Lordship, while explaining material facts, Lordship, at that point of time. So now, next, Lordship, I will come into the repetition, Lordship, to show your Lordship whether this shows any cause of action or not, Lordship. If Lordship permits, Lordship, on
We'll have to
Ne-
continue some other day. There's a meeting right now.
Lordship.
The both sides are represented. The submissions made by the P. Nayak, learned counsel for the opposite party, within bracket, election petitioner, remains inconclusive. List on. We are having a, we are fixing a date on 24th of October. We have two matters already for single bench.
Lordship. 24 Thursday.
এই খুলে দিব না টেবল বহুত আছে বহুত টেবল মানে আছে এইটো আজিৰটো হা একেলগতে টেবল এটাই মাৰো ইমান মাৰিব নালাগে এটা দুটা মানে 1 2 3 4 5 6 list again on 25 24 10 2024